জলপাইগুড়ি ম্যাটার লিভ দিয়েছিল আজকে কিসের জন্য আছে?
My lord, may I have your lordship's leave to mention item number 3 of the daily cause list, my lord, of our court, my lord, the daily cause list appellate side, my lord.
ঠিক আছে।
My lord,
Yes.
item number 3 of the daily cause list, my lord, has been pleased to mark it as after vacation, my lord. Now, my lord, there is a very small point, my lord, and the main urgency of me mentioning is that my lord remembers that I was suffering an order of status quo, and state came up with a proposal that 4,500 cards can be granted to Mr. Shaharai's client, and the raised cards can be granted to me, and another vacancy can be opened. Mr. Shaharai was also only to take instructions whether his client was agreeable to that or not. So the state has already separated the thing, and state has already solved the dispute, my lord. Only one, my lord, 30 minutes time will solve the entire case, my lord. If your lordship will...
Today I don't have the determination to fix the matter. Today I don't have the determination. Today group 6 matters.
No, my lord. I am just obliging your lordship so that the matter may not be marked as after vacation. The matter may be taken up before vacation at any day, my lord.
Okay. Tomorrow it was fixed matter.
Tomorrow it was 6 matter. Yesterday it was 6 matter.
So how can we done?
Yesterday it was fixed.
Yesterday 2 p.m. matter was fixed.
Could not be taken up.
Could not be taken up.
Accepting the views of the state, I have to argue the case. It is not possible before vacation.
Before vacation I have only 2 days.
The only motion will be taken up.
Only 7 and 8.
My lord, I understand that, but my lord, the worst sufferer is me, my lord. I will tell your lordship, because the thing is that the state has already segregated. Mr. Shaharai will also not suffer. I will also not suffer. Neither the another vacancy will suffer. Neither of them will suffer, my lord. State has already said that they will consider.
I understand the situation. I know the fact. But when the matter can be heard, today group 6 matters are there, not your matter. Yes.
But
Especially the same matter, my lord, item number 5 and 4 are 3 analogous matters. My lord, in item number 5, I am also a sufferer, my lord. My lord, if my lord, because if tomorrow, if my lord can take up the matter.
Tomorrow, how can I?
After recess.
Thursday, Friday, I have busy with group 6 matters.
Any day, my lord.
Any day, come on, then after vacation. Otherwise, I would have taken the matter. If the circuit is not there, I would have concluded this matter.
My lord is having
I know the fact. I know the fact.
My lord is having, sir, I was not obliged.
If my lord can fix a date even after vacation.
My lord can fix a date even after vacation, my lord. Yes, that will also serve a purpose, my lord. Any date after vacation, my lord. Mr. Shaharai is also there, my lord. My lord can pass an order fixing a date after vacation. পরে থাকবে আচ্ছা টপে থাকবে তো টপে অর্ডার আছে my lord the order was
going to appear in the list on 4th itself, 4th of November.
My lord.
Okay, no
obliged, man. Obliged. Deeply obliged.
Yes, call the list.
My lord.
Yes.
My lord, item number 159.
169.
आपका वकील कौन है?
देवाशीष मुखर्जी। नहीं आए हैं।
प्रहलाद कुमार।
हाँ।
क्या है?
डिफेंस लाइन में एसएसबी में है। प्रहलाद कुमार की मैं वाइफ हूँ।
क्या बोलना चाहते हैं, बोलिए।
सर, आज से मैं आई हूँ, 2 बच्चे, बहुत परेशानी हो रही है।
वो बात नहीं है, वो बात नहीं है। क्या बोलना चाहते हैं, बोलिए। क्या बोलना चाहते हैं, बोलिए।
ड्यूटी ज्वाइनिंग करवाने के लिए सर।
ड्यूटी ज्वाइन करने के लिए? किसका ड्यूटी?
पति के।
प्रहलाद कुमार कहाँ है?
बाहर में है।
बाहर में क्यों है? प्रहलाद कहाँ है? है अभी कोर्ट में?
हाँ, बुलाई हूँ मैं।
वकील को बुलाइए आपका।
साहब नहीं आ रहे हैं।
वकील नहीं है?
से बोल रहे हैं महाबड़ा स्टेशन पर है सर।
नॉट कमिंग।
हाँ।
वकील नहीं है तो क्या करेंगे ये केस लेके? केस रिकॉर्ड कहाँ है?
सर मेरे दो बच्चे हैं सर, बहुत परेशानी हो रही, मैं बिहार से आने में।
जब तक वकालतनामा दिया हुआ है जज साहब कुछ नहीं कर
वो
सकते।
तो नहीं आ रहे, हम कितना बार बोल चुके हैं। अरे तब हम क्या करें बताइए आप। फी भी ले लिए, पूरा फी भी ले लिए।
ऑब्जेक्शन लेके लीगल सोसाइटी से एक नया वकील अपॉइंट कर, तो ऑब्जेक्शन तो लगेगा ना।
आने से पहले
लीगल सर्विस अथॉरिटी एक होता है, लीगल सर्विस अथॉरिटी, ক্যালকাটা লিগেল সার্ভিস, ক্যালকাটা হাইকোর্ট লিগেল সার্ভিস অথরিটি, কোথায় অফিস কোথায় জানেন? ওকে ওখানে যেতে বলুন।
पुलिस है, अथॉरिटी है, आपको बता दें, बता देंगे वहाँ जाके बात करें।
उधर एक ऑफिस है, उधर जाके वकील ले आइए, ठीक है? आज नहीं तो कल आपका केस हो जाएगा।
थैंक
यस,
Now this is vacancy matter, my lord. I am filing my affidavit of service, and this is the usual article also. My lord, at page 17 is the license. For same place, vacancy has been published at page 18. Same place.
रामेश्वर सिंह,
My lord. Devottar Panigram, Matha Bhanga, same thing.
देवोत्तर पानीग्राम।
My same.
Similar direction. None appears despite service.
But I am filing it. But this is my area of operation.
Item number 2,
License at page
কত
19.
নম্বর আইটেম এটা?
Yes, sir.
Okay, this one. Have you served?
My lord, review service I have given, my lord. This is vacancy and declared in my area of operation, my lord. Clause finds Sital Kuchi, Gosariat, Kuchbihar.
एड्रेस दीजिएगा तो हम-
एक मिनट।
Location is not the same.
My lord, I am saying that this is my area of operation, my lord. That is, I am distributing in 4-5 places, my lord. That is,
Have you mentioned in the writ petition your area of operation?
my lord, I have mentioned not. Yeah. That is not mentioned, but my lord, you will find Sital Kuchi police station, similar Sital Kuchi, and Gosair Hat Bandar. Notice got my lord, my license, Gosai Hat Bandar and Sital Kuchi. In the vacancy also, that is,
You presume that your card would be delinked.
my lord, that is always there. That is PM.
Similar direction.
Deeply obliged.
দেখো।
Number 10, this is mine. For extension of anything or balance. That is the. This week, we got the vacancy of.
Hmm.
A report was filed by the state,
File the report.
or already filed.
Exception? Not necessary. So I'm fixing the date of hearing.
My lord, vacancy, my lord.
Okay, okay. Vacancy,
issue.
Same issue.
So there was an interim order earlier passed They are passed initially on 19th December 2023. Thereafter, this has been extended, my lord.
Okay.
Extend till disposal of the MAT 1543 of 2024.
Please take down. Incident matter appears under the heading of heading to be mentioned. Under the heading extension of interim order. It appears that this court
অনেকদিন আগে expire
has
Ishak 24 ছিল তারপরে তো
My lord, the interim order has expired.
expired.
Yes, yes. So the question of extension perhaps does not arise. It should be then they have to pray for novation.
19th December 2020.
They are the subsequent 30th January
30th
2024.
January, my lord, for a period of 4 weeks, my lord, they did not get the interim order extended. Lordship knows, my lord, the law is well settled on this. Unless they get it extended,
You have to file one application then.
yes, my lord, I am grateful.
You file a separate application.
I have not yet filed, my lord. I have mentioned the matter since the issue is pending before the division bench, my lord.
However, you have to file it, fresh
But I will
application.
Since it is over, I am grateful
Okay.
to your lordship.
Let the matter appear on 6th, my lord.
Okay. কি লিখেছো কিছু? দেখো না কিছু? ছেড়ে দাও। Let the matter appear in the list on 7th of October.
বলে দিয়েছি না না ম্যাডাম বলে দিয়েছি আমি দিদি না না আগের মাপটা তো একটু ওইটা বলে দেবো যশ সাহেব
Had mentioned, my lord, for a very small correction, my lord. It's, if your lordship sees one of the order, my lord, the name of the petition has come as Azizul, it should be Azizul, that's it. Instead of M, it would be L. Azizul Mondo, that's it.
M.
Yes.
M would be L. Please take down. This matter appears for correction. The next part, this matter appears for correction. Next part. The in the order dated 20th August 2024, in the cause title, the name of the appellant, name of the petitioner should be correctly read as Azizul, Azizul, instead of Azizum, Azizum. দুটো নামই ইনভার্ট মধ্যে রেখে দাও। Remaining portion of the order remain unaltered.
If your lordship calls up the next matter, my lord, একটু জলপাইগুড়িটা বলে দাও। I'm sorry to, my lord, জলপাইগুড়ি item number 2, my lord, Mr. Shumon Sengupta was appearing, my lord, his name has not gone down. It has been recorded as none appears. The Jalpaiguri division matter.
জলপাইগুড়ি
Yes.
ডিভিশন ম্যাচ item number
Item number 2 of Jalpaiguri division.
item number 2
Yeah.
সুমন সেনগুপ্ত
Yes, yes. I'm grateful.
সুমন সেনগুপ্ত
Item number 12, my lord, I am for the petition.
item number 12
This is for correction because in this description, the petitioner challenged the declaration of vacancy on the basis of existence of 2013 control order. But the order was wrongly recorded. In the order sheet, that was not reflected. Saying that order, my lord, a similar type of matter. I will
So I think the writ petition number is incorrect. That's why this order appears.
Petition number 23598 of 2024.
No, writ petition number 22510. What is the writ petition number?
23598 of
Yes,
2024.
that is the difficulty. That's why the entire fact. But I have dictated the order. Your order was not uploaded, separate order was uploaded. Separate order of separate rate petition.
But the
Perhaps
cause title is
cause title is correct, the number is incorrect. দেখে নাও এইটা না যেটা গন্ডগোল হয়েছে এই নাম্বারের চলে এসেছে এইটা দেখে এই কজ টাইটেলে কিন্তু এইটা list. You follow the list. In the list, the number is incorrect.
right. No, number is same. 22510 of 2024.
তাহলে এটা কিসের অর্ডার এলো এখানে? না না কারেকশনের জন্য এসছে ওনার, কিন্তু এইটা অন্য কেসের নাম্বার ঢুকে গেল।
Number is same. 22510 of 2024.
নাম্বার ইজ কারেক্ট। তাহলে এটা এই অর্ডারটা নয় তো বলছেন। অর্ডারটাই ভুল টাইপ হচ্ছে। আলী নিয়েছে, আলী নিয়েছে। হুম।
Instead of these order, that order.
I understand. No, this is the order on another in respect of another writ petition.
Yes, no, yes, that is 22509. এই orderটা
22509.
22509. This order was passed. This order also recorded in this petition.
Okay, 22509 order was also printed in 225010.
Yes.
This matter appears for correction. The order of WPA 22509 was printed in the instant writ petition. Accordingly, the order dated 11/9/2024 uploaded in the server be struck down, and its place the order mentioned herein should be printed. A similar direction হবে, ঠিক আছে?
This order
Yes, similar direction.
This writ petition order has been passed till disposal of the bunch of writ petitions, but which has subsequently been dismissed and appeal has been prepared. In the appeal order has, and your lordship, now your lordship is passing the order till disposal of the appeal. These have been happened this meeting.
You file a petition. You file a petition. Separate petitions, all the matter will appear on 7th. Let the matter appear in the list on 7th of October. All three. 13, 14 and 15.
My lord, 14 I am appearing, my lord. Led by my lord Mr. Suman Sengupta. I am giving the slip. My lord, we have also in 14, my lord, there is a report which has been prepared. Copy the reach. My lord, the reporter copy nahi yaar, chale. Reporter copy.
Give me the report.
My lord, I'll file the report. Copy. My lord, there was, my lord, 2 orders passed in this matter. One was, my lord, on 5th of April, wherein, my lord, My lord, Civil Food Security Act, my lord, control order issue. There was a
এখন মার্চ হয়ে গেছে না এখন।
no, ওখানে তাই ছিল। Considering my lordship will find my lord the penultimate paragraph of 5th April order. Considering the aforesaid submissions, state authority may proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued till the disposal of batch of other writ petitions being WPA 22281 of 2022 and others.
Yes. This is the order.
This is the order, my lord, and my lord, I'll indicate my lord something else after this, my lord. My lord, the subsequent order of 6th of August, my lord, the name has, my lord, it should be, my lord, Mr. Sambuddha Datta instead of, my lord, the name which has been recorded.
Mr. Swapan Kumar Datta.
My lord, yes, my lord, because of, my lord, the slip, my lord, the clerk, my lord, we share the same clerk, my lord, the clerk mixed up the slip. That is the, off the record, the truth of the matter.
Okay. Please take down. Learned Counsel represented on behalf of the state on 6/8/2024 has been wrongly written. Learned Advocate Mr. Suman Sengupta with Mr. Samudra Dotto
I am grateful.
and Sanatan Paja should be written as representation on behalf of the state in the order dated 6/8/2024. Office is directed to make out the correction. Full stop. Next para. The report in the form of affidavit filed on behalf of the state respondent is taken on record. Petitioner, exception if any, be filed by the petitioner within 2 weeks from date. Full stop. Petitioner intends to file a separate application. According the matter be adjourned today, list the matter on 7th.
Grateful to your lordship. I'm great.
Same. 15 will also appear on 7.
Let the matter appear on the 7th.
16, my lord, it is one of those notification matters, my lord. Earlier, lordship had, my lord, passed an interim order, my lord, for a limited period, my lord. I was praying, my lord, for extension of, in fact,
I appear on behalf of the state, my lord, led by Mr. Swapan Kumar Datta.
Yes.
if your lordship sees, my lord, the order dated 3rd of July 2024, my lord. But I had mentioned this matter, my lord, for extension, my lord. Now, my
But
lord,
I have,
order may be passed, my lord, as passed in the other matters, my lord.
Whether the affidavit is ready?
my lord, I have already filed my report in the form of affidavit, and I also served my upon the my learned friend.
No,
my
it
lord.
was not filed.
Yes, my lord. Since I am today, I am
You have
not.
filed?
No, my lord. Today I have affirmed and served. But since I am not
Yes.
available today in physical to court physically,
They have served upon you?
That I'll have to check with my advocate record, my lord. Sure.
Okay. Please take down. Learned Counsel appearing on behalf of the state authority. Swapan Datta আর ওনার নামটা নেই।
but I am putting my name in the chat box. my lord.
Yes. নিয়ে নেব। Submits the affidavit in opposition.
Affidavit report in the form of affidavit, my lord.
Report in the form of affidavit is ready to file. Full stop. Learned Advocate for the petitioner seeks extension of interim order passed by this court on 7th of July. 3rd of July.
3rd of July,
2024. Full stop. Heard the learned advocates peruse the materials. It appears that the similar issue is pending before the learned division bench, being MAT in a batch of appeals in MAT 1543 of 2024. Full stop. It further appears that the Honorable Division Bench has already issued an interim order in that appeals concerning the situation. The interim order passed by this court on 3rd of July 2024 is further extended till the disposal of the MAT 1543 of 2024 or until further or whichever is earlier.
Grateful, lordship.
Let the matter go out of the list.
Right.
Call group 6.
Here, post of appointment of ANM, but under the Health and Family Welfare Department, your lordship knows, but the auxiliary nurse welfare training, but the
This is item number
but 128.
128.
Yes, Savitri Jana.
Yes.
Yeah, for the post of appointment of ANM, under the Health and Family Welfare Department, the candidate has to go through to a phase of training, nursing training. Initially, my client's name, the petitioner before your lordship, in 2009, her name was being selected for the purpose of undergoing a training. I shall show before your lordship that clause. The training, for the purpose of training, my client went on joined the training, but subsequently what happened? She gave birth of a child. Simultaneously, her husband was also detected colon cancer. So, subsequently, she could not able to continue with the training on that phase. Subsequently, in 2015, her name again sponsored for the purpose of undergoing the training. But the department asked for certain document over which it has been detected that the earlier in 2009, the same candidate is being sponsored for undergoing a training, but she couldn't able to complete that. In the meantime, I made a representation, but applying in 2015 rules means the procedure has laid down in the appointment process. They have cancelled my candidature, saying that once your name is being sponsored for the purpose of undergoing a training, nursing training, and you couldn't able to complete that, so your name cannot be sponsored second time. Now, 2 pages I shall show before your lordship. If your lordship kindly comes to the first phase training that was sponsored at page 24 of my lord's brief. Has your lordship got it, Milord?
Yes.
Your lordship will see, Milord, the date is at the top, 17th of November 2009. The name of the petitioner is there. You should positively report 3 days on and from such and such, failing which the candidature may be cancelled. Milord, that reporting was being done. At the time of admission, you should bring medical certificate, enclose such and such. Milord, the criteria, copy of the bond format, entitlement of 500 rupees stipend, Milord, that has been mentioned. And selection or admission is provisional, subject to decision of the court cases pending. Milord, this is the usual format over which I, Milord, joined but couldn't able to complete my training. Now, Milord, if your lordship compare it with page, Milord, the second where, Milord, I have been selected, page 34 of my lord's brief. I shall, Milord, compare these two before your lordship. This is the subject matter, page 24 and 34. 34, my lord, has kindly be got.
Yes.
Yes, Milord. 34, this is 19th of March 2015. This is the second phase, Milord, wherein my name is being sponsored for undergoing a training. Kindly see, Milord, the clause number 3. Being an officer of the court, Milord, I must point out this to before your lordship. Failure to join training course in time or leaving the course midway for any reason whatsoever will result the candidate being cancelled, candidature being cancelled. This is, Milord, incorporated in 2015, but not there in, Milord, page 24, which was there in 2009. So, Milord, on the basis of this, my lord, kindly turns over the page and comes to page 36. Serial number 3, my lord, would get my name is being sponsored into a 2015, wherein this clause is being incorporated. If you couldn't able to join or discontinued, your candidature will be cancelled forever. Now, kindly turns over, my lord. I made a representation. My lord, kindly turns over then page 37. Since, my lord, relevant document is being asked for, this is, my lord, a subdivisional officer writing to the mission directorate that in response to the above, as per the statement of the petitioner, I am to state actually Savitri Jana, my lord, the petitioner before your lordship was selected as second phase. Accordingly, her name was sponsored from the end vide office memorandum dated, my lord, this is of 2009, to the director ESI Hospital Shialda, which I couldn't able to complete, along with her original application and other relevant papers. There is no record at this end since the same has already been sent. Thereafter, my lord, I made a representation, page 38 and 39, so that they can consider it, because in 2015, my name has been considered and papers are already there. Kindly see now, my lord, the order, page 41. That is, my lord, this ultimately impugned before your lordship. My lord, representation is being considered apropos to your letter dated such and such on the subject caption.
No, what represent? Why you made the representation? You were selected.
No, my lord, since I have been selected, but since my papers are not being, my lord,
What
say,
paper?
my lord, this SDO has to send the credential, my lord, at the time of my making application, whatsoever is there, that was sent, my lord, in 2009 itself.
No, you have been selected for the training.
Yes,
That's why you given the memo 19/3/2015.
I'm grateful, my lord. But
Thereafter,
they are not, my lord, allowing me to join in the training in view of the fact that in 2009, this memorandum I have read before your lordship, page 37. Since SDO has written to the mission directorate that I have already undergone a training, or rather joined a training but couldn't able to complete, no papers are lying. Due to that discrepancy, I was not allowed. So I made the representation.
what papers they require?
At the time of making application, I will have to give in some credential, my madhyamik, uccha madhyamik, and thereafter other credential that has to be sent, so that they can scrutinize it. Thereafter, allow me to undergo the training, and at the result of the training, if I succeed.
So what is your case? You have already sent all the original documents.
Original document. I have annex also. That is no dispute with regard to that. Kindly see the cancellation order at page 41.
Yes.
With regard to that, there is no dispute. Apropos to your letter dated such and such on the subject caption, you are hereby informed that the office has no scope to consider your further training and subsequent engagement as contractual second A&M for the said subcenter on the ground mentioned below. Kindly see point number 1. As per the office memorandum, they are giving this of 2015 memorandum. Failing to join training course in time or leaving the course in midway for any reasons whatsoever will result in the candidature being cancelled. This is of 2015. I have shown before your lordship. Previously, it was not there. Secondly, as per the office memorandum dated 2015, again they are referring this. No further proposal for approval towards training and subsequent engagement of contractual second A&M shall be considered. By this end, any panel, if prepared for the purpose, shall be treated invalid and shall cancel with immediate effect. This, in my respectful submission, my lord, is something which has been given effect in 2015, but my case is not covered in 2015. Even if my name considered, if I fail to complete it in the 2015 training course, then they could have applied this provision. This is my respectful submission. Without applying 2015 clause, they should have considered my case afresh, so that I can undergo the training. Even my client instruction, she can forego whatsoever the stipend amount. She can also be permitted to take all the training at her own cost also.
Yes.
My lord, I have to take instruction in this regard, my lord.
Instruction. What instruction you need?
My lord, since he has applied for second time and his by memo dated 19th of March 2015, it has been cancelled, my lord.
I understand. So what is the procedure for selection
That
of
my
a candidate?
2020 matter, they have suddenly mentioned the matter.
My candidature has not been cancelled.
No,
my name
2009, 2011.
Yes, my lord.
2011 he was selected.
2009.
2009.
So 2015.
She could not completed the
I understand.
course, my lord.
2015 she again selected. Who select him? Who select her?
My lord, that is
There is a procedure for selection.
that to that effect, my lord, instruction is required.
This is the official memo 19th of March 2015.
It is categorically stated, my lord.
She has been selected.
Yes, mission director.
Mission director selected.
Yes.
Then
My
after
lord,
selecting the person, how
my
can
lord,
you
may
divide?
I come back with instruction, my lord? Otherwise, my lord, it is
It is a
difficult.
very small issue. So
Only they will have
My
to
lord,
consider.
then consider his.
yes, I am directed to consider stating all the reasons.
Yes, my lord.
Please take down.
With your lordship's leave, my lord, may I?
Yes.
I'm extremely.
the petitioner was selected for undergone a training for ANM capital within bracket R course R close. Accordingly, a memo was issued on 17th/11/2009 by the Subdivisional Officer Kontai Purva Mendipur, directing the present petitioner to report positively within 3 days on and from 30th of November 2009. Full stop. 9 at before the director ESI Hospital Sialda. Full stop. On such memo, the petitioner has joined the training. Full stop. Next, it is the case of the petitioner that due to sudden pregnancy, due to the pregnancy of the petitioner, as well as the illness, serious illness of her husband, she could not complete the training program. Next para. Subsequently, the petitioner was again selected by the mission head for the provisional admission of training of ANMR course, ANM capital R within bracket course for second ANM in subcenter. Full stop. Vide memo dated 19th of March 2015. The mission director NHM has selected as many as 9 persons, including the present petitioner. However, vide memo dated 28th March 2015. A letter was issued by the subdivisional officer Kontai to the mission director containing inter alia that the present petitioner was selected as second ANMR and accordingly her name was sponsored by the office memo dated 17/11/2009 to the director ESI Hospital Sialda. Reasons thereof, the credentials and documents of the petitioner could not be sent for the training program. The petitioner has made detailed representation to the authority concerned, and ultimately the program officer, National Health Mission West Bengal, and Deputy Secretary, Health and Family Welfare Department, Government of West Bengal, has issued a memo on 1st of August 2019 to the fact that the name of the petitioner cannot be considered as she could not complete the training program by virtue of the memo dated 17/11/2009. For the learned advocate, peruse the impugned memo dated 1st of August 2019. It appears that the program officer has issued the memo by virtue of the directives and the rules mentioned in the memo dated 19 March 2015 issued by the West Bengal State Health and Family Welfare Samiti National Health Mission within bracket annexure P6. The rider which was rider was mentioned in clause 3 of the memo as follows. বলে খরচ এটা করবে, হয়েছে? এইটা পেজ 34 হয়েছে। It appears that the program officer has not considered the present petitioner for training purpose, showing the reasons enumerated in memo dated 19/3/2015. However, there are no such rider in memo dated 17/11/2009, wherein the present petitioner was directed to join Director ESI Hospital for the training program. It is the fact that the petitioner has, next paragraph, it is the fact, has joined the training program on 30th of November 2009 with the Director ESI Hospital Sialda, but subsequently she could not complete his hard training. However, as the memo dated 17/11/2009 does not mention a rider as appear in 19/3 and as appear in memo number 19/3/2015. Thus, the impugned memo dated 1/8/2019 passed by the program officer is program officer on the basis of the memo dated 19/3/2015 appears to me erroneous. It is true, next part, it is true that the petitioner has the cause and reason for not completing the training. Considering the circumstances, the memo dated 1/8/2019 is considered rejected. The program officer is directed to consider the representation of the petitioner in humanitarian angle and pass a decision order within 6 weeks. Within 6 weeks from the date of passing of this order. From the date of communication of this order. From the date of communication of passing of this order. From the date of communication of this order. The decision taken by the program officer has to be intimated to the petitioner within 2 weeks thereafter. Under the above observation, the petition is disposed of. Yes.
Governed by this input order, Lordship. She would be motivated, Lordship, earlier input order. That should be set aside and quashed and.
It was set aside. The impugned order was set aside. It was set aside. 1st August 2000 order, it was set aside.
My lord, Mr. Vishwabroto Bosumalik appearing behalf of the state respondent, my lord. My lord, I am praying for not today, and my lord, please, my lord, kindly directed to serve the copy, my lord. We have no brief, my lord. We have no
Item
copy.
number 129.
Yes, my lord.
What is the matter?
Actually, the matter is about the petitioner seeking direction for a job on a compassionate ground. This is a matter of.
My lord, here,
But we have
You
no
don't have
copy,
the
my
brief?
lord. No, my lord.
in earlier occasion, order has been passed by this Honorable High Court with a direction to consider the representation of the petitioner regarding the compassionate appointment of the petitioner within a period of 6 weeks, and after giving opportunity of all the parties. And that hearing was held, and District Rural Panchayat officer, my lord, find that after inquiry that I have required the appointment because the petitioner is in financial crisis, and that intimation was given to the director of the panchayat, and director of panchayat returned the application with some queries, and that is in the year 2020. After considering all the facts as per their queries, I sent all the papers to the authority concerned, and till that they did not take any steps of the case of the petitioner under compassionate appointment. The father of the petitioner was working as a
So
panchayat.
you have filed the writ for prompt decision.
I filed the writ petition in the year 2021, and queries has been seeking from the district panchayat of
2020.
2020. And from that period, my lord, they did not take any steps, and they did not
Take any decision.
no decision, no steps, nothing.
So why you file this writ? For the necessary direction to so that the matter can be disposed of.
Yes, my lord. My lord, if your lordship kindly say the last page, that is page 25, the the deputy
Where is the order, earlier order?
earlier order, my lord, that is page 16.
Page 16.
Page 16. And my lord, the ordering part is 17. That is under this backdrop, I direct the concerned respondent number 4, the block development officer, Pathor Pratima Development Block South 24 Parganas, to consider and take a decision in respect of the petitioner representation dated 1st June 2015 as well as 12th May 2017 in accordance with law within 6 weeks from the date of communication of this order, after giving an opportunity of hearing to the petitioner or his authorized representatives, and thereafter communicate the decision to the petitioner within 1 week. Well, that order has been passed in the year 2017. If your lordship kindly see the date of passing of the order, that is
Yes.
13/7/2017. And after that, intimation has been given, and page 19 is the hearing held by the office of the block development officer. Page 19, 19.
So hearing was taken.
Hearing was held. And page 20 is the recommendation that is given by the block development officer to the district panchayat rural development officer. That's
Block development officer has given the hearing.
Yes, yes. That is block development officer specific statement is that in
Page 20.
Page 20. With reference to the subject cited above, the undersigned is sending herewith pro forma application with all enclosure and 3-man committee report in favor of Sri Pratim Jana, Shanam such and such, ex Panchayat Korbi of Lokkikantapur Gram Panchayat.
Recommendation has been made.
Yes. Page 20 recommendation has been made. After that, page 21 is the my lord block development officer, district panchayat send all the papers to the district panchayat rural officer for taking necessary steps. That is page 21.
That is 2018.
2018. And after that, page 22 is the district panchayat rural development officer intimated to the block development officer to send some papers with application form, and as per requirement that was sent to the district panchayat officer, that is page 23. That was sent on 29/10/2018. And if your lordship kindly see for a moment, page 24, district panchayat rural development officer also recommended for giving appointment to the petitioner. That is last para. In this connection, I am requesting you to accord necessary administrative approval for appointment of the applicant as shown in Annexure 1 on compensation ground. That is recommendation made in the year 2019 from the district panchayat rural development officer to the commissioner panchayat rural development department. And after that, my lord, on 2020, district panchayat rural development officer, some queries has been sent and requested has been made to send some papers. That was page 25. That is returning here with the proposal for appointment on compassionate ground in respect of the applicant as stated below, due to reason as noted in the attached check memo. Please write the serial number of the application during resubmission. That was the queries, and as per queries, page 26, the petitioner already submitted all the documents. Again, resubmit. And that was made in the year 2021. 19 January 2020.
What is the post?
Malad post is the Panchayat Kormi.
Karmi.
Yes. And 19th January 2021, that was sent to the department. And till date, nothing. Even specific direction given by this Honorable High Court. And district panchayat rural officer already sent recommendation in favor of me that I have need service under compassionate appointment. From 2020, my lord, the queries has been made by the district, that is.
Yes, what is your submission?
Yes, my lord, we have no brief, my lord. My lord, kindly direct to serve the copy, my lord.
That already I
That
served.
matter is, my lord,
Already matter has been disposed of by this court earlier occasion. You have to take the decision only. This is the issue. Nothing is that.
my lord, without brief, we cannot collect any type of report or instruction, my lord. Kindly, my
And my lord, from 2021, the petitioner is struggling from pillar to post. In spite of specific direction by this Honorable High Court as well as.
No, let me pass whether there is any direction for filing report.
No.
Let me take out. Okay. Let me take out the report from the why there is delay. Please take down. The appointment of the petitioner as Panchayat Koni under the compassionate appointment. The appointment of the petitioner Panchayat Koni. For the under the ground of compassionate appointment was placed before this court on the earlier occasion. Full stop. A coordinate bench of this court on 13th of July 2017 passed a specific direction upon the authority concerned to consider the representation of the petitioner and pass a written order. However, the representation of the petitioner was considered. The hearing was held by the block development officer. Necessary documents were forwarded, but till today, no effective steps has been taken for appointment of the petitioner on compassionate ground. The petitioner has sent all the documents, including the inquiry report of the block development officer has been sent to the department. Full stop. Next, having heard the learned counsel for the petitioner, it appears to me that the state authority need be submit a report to enlighten this court regarding the situation of the instant matter. Under the above observation, the state authority is directed to submit a report in the form of affidavit within 2 weeks from the date of passing of this order. Exception, if any, we filed within 1 week after reopening. Let the matter appear in the list on 14th of November. Under the same heading. 14th of November.
Under the same heading.
Under the same heading.
Great.
Copy search করে দাও। Grateful man.
Upright fine. Compilation.
Yes.
May it please, your Lordship, your Lordships recall that this matter relates to the placement of the writ petitioners in the proper scale, pay scale, which they actually belong to, Lordship. There have been unilateral expansion of pay scales without
Yes.
any approval of the competent authority. Lordship, on the previous occasion, I had pointed out to your Lordships that right from the beginning, if your Lordships take the memo dated 8th of April, the Finance Committee, that it was admitted that there was no approval because Lordship sees that the Bose Institute is an autonomous institute, fully funded by the Government of India.
Yes.
Now, Lordship, in case of these autonomous institutes, Lordship, these autonomous institutes are governed by the general financial rules, Lordship. Now, and Lordship, these rules were initiated in 1963. And in 1963, the provisions were that all autonomous bodies or grantee institutions which receive more than 50 ওটাতে 63 দেখলাম হ্যাঁ যাই হোক 63 টা দিয়ে Lordship, the financial rules had come into play in 1951. I was tracing back from when they were in existence. Now in 1963 rules, which I shall be handing over, that all autonomous bodies or grantee institutions which receive more than 50% of their recurring expenditure in the form of grants in aid should formulate terms and conditions of service of their employees so that, by and large, they are broadly comparable to those applicable to similar categories of employees in the central government. Thereafter, Lordship, the rules have been amended from time to time, and it was amended in 2005,
Yes.
and lastly in 2017, Lordship, and that rule has been well, Lordships will find it in the affidavit in opposition filed by the Bose Institute, where Rule 230, that which was 149 is now Rule 230. 230.12 says, all grantee institutions or organizations which receive more than 50% grant of their recurring expenditure in the form of grants in aid should ordinarily formulate terms and conditions of service of their employees which are, by and large, not higher than those applicable to similar categories of employees in the central government. In exceptional cases, relaxation may be made in consultation with the Ministry of Finance. Therefore, Lordship, they have to restrict themselves so that they are not higher than the central government employees, and any relaxation has to be taken with the permission of the Ministry of Finance is a must, Lordship. So that is what all autonomous institutions are governed by. They cannot, in an unfettered manner, when they are totally dependent on grants, I mean, above 50%, in this case, it's a fully financed institute,
Yes.
Lordship. They cannot, Lordship, of their own, increase the pay scales, Lordship.
Your affidavit in opposition, let me take it.
Lordship, of the central government?
Yes.
Yes, Lordship.
Give me the affidavit in opposition of the state.
Lordship, affidavit in opposition of the central government.
Central
Lordship. Yes, Lordship. Lordship, I'm placing the affidavit. Lordship, I found it. It was affirmed on the 25th of November. Stamp is 20. No, that is Bose Institute, probably. I am respondent number 1, 2, 3, and 4.
1, 2, 3, and 4.
Yes, Lordship.
দেখুন তো এইটা আছে। Yes.
Lordship. Lordship, in my affidavit in opposition, I have stated categorically that Lordship will come to page 2 is where the Bose Institute, Kolkata, is an autonomous institute under the administrative control of the Department of Science and Technology, Government of India. This is a grant and aid institution of the Department of Science and Technology. Bose Institute is a research institute engaged in research, and the affairs of the institute are managed by a governing council in accordance with the instructions issued by the Government of India from time to time. The present writ petition has been filed against the directions issued by the Government of India for taking corrective steps with regard to impermissible, irregular, and unentitled fast-track financial upgradation promotion almost in every 5 years.
Yes.
Given without approval of the competent authority. Lordship, I'd shown your Lordship's the rule. If there has to be any relaxation, anything, then there has to be a permission from the competent authority, Lordship. Without the approval of the competent authority in respect of the administrative and technical staff of the Bose Institute. Then this is not a case where the Government of India has directed to withdraw any due promotion or entitled financial upgradation which have been made against existing vacancies, Lordship. But the directions are in the nature of rectifying, taking corrective steps to bring those employees in the pay scales for which they are entitled, Lordship. The submission of the petitioners that pay scales have been enjoyed for more than 14 years and are being brought down with retrospective effect is illegal and incorrect, as the wrongful and irregular financial upgradation promotion without any vacancies to the upgraded scales cannot be continued, being irregular and not covered by any such schemes having approval of the competent authority, that is, the Department of Expenditure, Ministry of Finance. Lordships have heard the matter in details. Competent authority has been explained in various ways. When the council says this, it's been interpreted as a competent authority. But where the finances are involved, Lordship, ultimate authority is the Department of Expenditure, Ministry of Finance.
Yes.
In these cadres, 5 to 6 pay scales have been upgraded, whereas at best only 3 functional upgradations under the modified assured career progression scheme duly approved by the Government of India is permissible for these cadres, besides vacancy-based promotion. So the promotions could have been either vacancy-based or through the in situ promotions through ACP and subsequently the MSCP. That such discrepancies and highly irregular financial upgradations have come to the notice of the Government of India during the course of the implementation of the 7th Central Pay Commission to the employees of this institute. In order to extend benefits of the 7th Central Pay Commission, the employees of autonomous bodies funded by the central government, conditions of the service of employees of these organizations must be similar to those in the case of central government employees, and the revised pay structure shall be admissible to those employees who opt for the same in accordance with the extant rules. Further, in case of those categories of employees whose pattern of emolument structures, that is pay scales and allowances, and conditions of service are not similar with those of the central government employees, a separate group of officers in respect of each of the autonomous bodies were constituted in the Department of Science and Technology. As per the Government of India's instructions dated 13th of July 2017, which is annexed as Annexure P11 to the writ petition. Lordship, I'll just place it. It was also necessary to ensure that the financial benefits proposed to be extended to the employees of the autonomous organizations like Bose Institute was not more beneficial than that admissible to the corresponding categories of the central government employees, Lordship. Now, Lordship, pausing for a moment, if we turn to the memo dated 13th of January 2000,
13th of January 2017.
17, Lordship. This is where the group of officers are. It's in Annexure P11. No, not P11. Sorry, Lordship. It's just a minute, Lordship. It's written P11 in
page 54 of the writ petition.
Page. Deeply. Anandamoy Aduk, na Joyshish. Yes, Lordship. Anandamoy Aduk doesn't have that problem. আছে 13/7 2017
You see Joyshish.
Joyshish is
Joyshish have that.
Yes.
Page 54.
Actually, that was a mistake. The P11 was Joyshish. Lordship, I'm placing the, if your Lordships have found the memo, I'm placing it from my compilation.
Page 93.
93. Yes,
Page
Lordship.
93.
Lordship 93.
Next
Page
P17.
93. I was looking for this. P17, not 11.
Page
Sorry. 93, Lordship.
Memo dated 13th January.
Yes, Lordship, this is the starting point. P17, Lordship. This was the office memorandum issued by the Ministry of Finance. Now, Lordship sees pay revision of employees of quasi-government organizations, autonomous organizations, statutory bodies, set up by and funded and controlled by the central government. Guidelines regarding the employees working in the quasi-government organizations, autonomous organizations, statutory bodies set up and funded, controlled by the central government are not central government employees, and therefore the benefits implemented by central government in respect of central government employees as part of their service conditions are not directly applicable to the employees working in such autonomous organizations. The application of such benefits is given to central government employees in respect of employees of such autonomous organizations, as well as the manner and conditions governing such application, including sharing of the additional financial implications arising thereon, requires specific approval of the central government, Lordship. The autonomous organizations are expected to manage their affairs in such a fashion that their dependence on central government for financial support to meet the extra implications is minimal. And as such, that is the expectation, Lordship. Lordship, in the above background, para 2, the question of extension of the revised pay scale in terms of the CCCSRP rules, revision of pay rules 2016, in respect of the central government, based on the recommendations of the 7th Central Pay Commission, to the employees of quasi-government organizations, autonomous organizations, set up and funded, controlled by the central government, where the pattern emolument structure, pay scale houses and dearness allowance, house rent allowance and transport are identical to in those cases of the central government employees has been considered for the government, and it has been decided the schedule as well as the principle of pay fixation as contained in the said rules may be extended to the employees organization on the following stipulations. So this is where the government Ministry of Finance decides to extend the benefits of the 7th Central Pay Commission to the employees of the autonomous institutions, Lordship. What are the conditions? One, the conditions of service of the employees of these organizations, especially relating to hours of work, payment of OT, are exactly similar to the central government employees. Revised pay structure should be admissible to those employees who opt for the same in account with the extant rules. Deductions in account of Provident Fund contributory profit. The revised pay scales the deductions on account of Provident Fund contributory, the revised pay scales contained in Parts B and Part C of the schedule shall not be automatically applicable to the employees of the autonomous organizations. The concerned administrative ministry shall consider that such cases keeping in view of these pay scales are justified for the category of staff of the autonomous organizations based on functional considerations, recruitment qualifications, as well as applicable pre-revised pay scales. Based on such examination of the concerned administrative ministry for appropriate proposals, if justified, should be submitted to the Ministry of Finance. In case of categories of employees whose patterns and emoluments, pay scales, conditions are not similar to those, a separate group of officers in respect of each of the autonomous bodies may be constituted in the respective departments. The financial advisor, this is how the group of officers are formed, Lordship. It will be, and what it will be necessary, Lordship, I'm just leading 5 lines above that paragraph. It would be necessary to ensure that the final package of benefits proposed to be extended to the employees of these autonomous organizations are not more beneficial than that admissible to the corresponding categories of the central government employees. The final package recommended by the group of officers will require the concurrence of the Ministry of Finance, Lordship. So this is how the group of officers was formed for implementation of the 7 CPC in respect of the employees of the autonomous institutions. Lordship, so
Staff representative, the expression of views change still a revision of expectation relation to name.
the Lordship, the financial advisor will represent the ministry. The group will examine the proposals for revision of pay scales, taking out views, if any, expressed by the staff representatives of the concerned organization. Lordship, this is where, Lordship, they had I shall come to Lordship, pursuant to your queries, I shall be placing, Lordship, that whatever was given, but this comparison, job responsibilities and the pay scales, Lordship, that was never deposited. That is, I should be there because much reliance has been placed on a tabulation, and as I had submitted earlier, job responsibilities were not, it was only the job responsibilities of the BI staff, what the corresponding staff do. So the comparison of the, if your Lordship can recall the table of the DRDO, where much reliance has been placed on the table of that comparative figure, Lordship, there was no comparison with the responsibilities discharged. It was merely posts which were stated, and there too we find, Lordship, I had pointed out that there were pay scales which were much higher than DRTO. That was also there. I shall again point out those. So Bose Institute was enjoying scales, even in that tabulation.
So whether you are arguing that the consideration, functional consideration, recruitment qualification, as well as the applicable pre-revised pay scale are different to that of the DRDO and the Bose
Lordship,
Institute?
yes, Lordship, because that comparative figure, Lordship, was not there. They have just Bose Institute and DRDO.
Whether that comparative figure was considered by the group of officers?
Lordship, group of officers, yes, Lordship, I shall be placing that to your Lordship.
What considers by the group of officers that this is the quality that they should not be given such?
No, Lordship, group of officers had taken everything into account. What the pay scales, Lordship, they had given, the pay scales, the tabulation was.
No, group of officers
Lordship,
is your opinion that the memo issued by the Bose Institute
was,
is
yes,
not under the authorization.
Lordship, that is
That
there.
they have,
That memo issued by the Bose Institute.
It is not
Now,
under the authorization.
the comparative table is based on that memo, Lordship. The comparative table was what they were enjoying based on that memo. That memo itself, without that memo itself was per se illegal.
No, their memo, which was struck down by the group of officers or the central government, is that the memo saying that this organization was providing this facility, we are also giving this facility subject to the fact of the approval of the fact of the approval of the central
without an approval, Lordship, because that
it is the opinion of the group of officers that this memo without authority, and
the memo was issued without authority, admittedly, Lordship. I had placed that, I'll come to it again. That memo, while the minutes we find, there was no authority. But it seems that just to buy peace in the institution itself, the pay scales were given. And it was, the employees were made to say that should there not be no, you will have to return, not DRDO, Lordship. DRDO was
at par with other institutes.
Other central, no, Lordship. I'll just explain. Lordship, the memo had adopted the pay scales adopted by the Indian Association for Cultivation and Sciences. And they had taken that, they had relied on the memo dated 1979, which said it should be at par. And that was there. This was from that memo, we find that was during the comparison with the Calcutta University pay scales. But even there too, Lordship sees, there too, the principle of it cannot, I mean, Lordship, I'll just place the memo, which was taken, which was the prime reason for consideration. They said we will.
1979.
1979.
Prior to central government.
Prior to central government, that too, it had to be at par with Calcutta University.
Calcutta University.
Nobody, I mean, the funding, it has to be the pay scales enjoyed, cannot be more. Unless their work, responsibilities, take it into account. The tabulated tables, Lordship, the pay scales, Lordship, those pay scales, Lordship, were based on the.
So the Bose Institute was under the central government in the year 1983.
Lordship, that is what
that is the 1983 or 84.
Whatever it is.
Thereafter, a sixth pay commission was implemented.
Lordship,
they have given the sixth pay commission benefits.
Yes, Lordship. Sixth pay commission benefits they have been given. And they were also enjoying from 2008, Lordship. This memo had taken place. So the employees had got all the benefits, which, Lordship, was without any authority.
Okay.
Lordship, that is the
one question
yes,
regarding
Lordship.
The scope of promotion. If central government is saying only SCP or MSCP or the vacancy based promotion.
Lordship.
And their argument is that no such promotion is provided according to the MANA scheme. They are
Lordship,
keeping.
Mana scheme, Lordship, I have taken instructions also, Lordship. I'll be coming to the queries that your Lordship had placed. Lordship, Mana scheme was also not an approved scheme.
Not approved scheme.
No.
Okay.
That is my instruction. Mana scheme, Lordship. Lordship, Lordship, I think I have answered the first query whether there were any guidelines, Lordship. The guidelines are, Lordship, I think it's better if I hand over the, Lordship, I'll make a compilation, Lordship, and hand over these two, or shall I just?
Yes. Please.
I think that will be better, Lordship.
Please.
So the guidelines are the general financial rules of the Government of India, firstly. So, and I had placed the rules. Now, another query was and therefore, the rules of the Government of India, promotion has to be either vacancy based or through ACP. Lordship, the memo that much reliance was placed on the by the petitioners relating to at page 55, Lordship. That is Lordship will kindly come to page 55.
Page 55. Page 55 of the writ.
Lordship,
Justice.
no, Anandamaya. Anandamaya Dukte diye rakhun. I have Anandamaya Dukte. Lordship, this relates to
recruitment rules for posts.
Lordship, promotion policy of non-academic staff. That is the letter dated 1st August 2001. Lordships have found it. Annexure P2, page 55. Found it, Lordship? आके देखलाम हाँ आनंदमय यादव की It's
page 50.
Page 55. It's a letter dated 1st August 2001.
No.
Should be flagged, Lordship, because this is Anandamaya.
Anandamaya.
Yes.
Main writ petition.
Main writ petition.
Yes.
Page 55.
Page 55 is otherwise. Okay. Reply. Oh, okay. Got it. Let it No. Just
and what a flag for you.
First of August 2001.
Yes. Lordship, this is where the promotion policy for non-academic staff, in pursuance of the decision taken on agenda item number so-and-so, the Bose Institute Council, a promotion policy was formulated by the Bose Institute in respect of non-academic staff, administrative and technical. And the promotion rules for non-academic staff were referred to the DST for final approval. The promotion rules were discussed in a meeting and the broad conclusions were arrived at. Promotions of administrative staff will be vacancy oriented. In other words, such promotions have to be against vacancies arising against sanctioned posts and not made on time-bound or interim or supernumerary basis. In this regard, the principles evolved in the meetings held in DST on 5th July 1996 and 26 February 95 regarding promotion and other matters should be kept in view. There is no objection to the ACP scheme of the central government civilian employees introduced dated 9th August 1999 being introduced in Bose Institute. The promotion of technical staff may be done in the pattern of CSIR manners, qualifications, experience, and the level up to which an employee can rise may be reviewed in the light of the above scheme. May be done, may be reviewed. It did not say like the other twos were promotion, vacancy based or ACP. That was no objection. Here, give it a try. You can review it. The particular group may be reviewed in the light of that scheme. The promotion scheme may be reviewed in the light of the foregoing and the matter placed before the governing council again. So, Mana scheme was not, as it has been represented, that Mana scheme was the final for the technical staff. No. Then it may be reviewed and placed before the council for further review. So this was the position of the Mana scheme, which was
no, Mana scheme was not properly denied also in this memo.
Lordship, it was not denied, but it was not given either.
So what is the decision that it was denied?
Lordship, the decision is you can review it in comparison with the pay scale. That is the study the Bose Institute had to do to see what happens. Otherwise, promotion, vacancy based or ACP.
The promotion scheme may be pleased to review it in the light of the foregoing matters placed before the governing council against the reconsideration. Again, for reconsideration, it was placed before the governing council for reconsideration. Whether
Yes,
the governing council has been.
Lordship, I should be coming to that.
Yes.
I shall be coming to that. So, no, this is, in fact, Lordship, I was inquiring whether it was at all implemented or not.
Yes.
Lordship, my learned friend will be able to satisfy, but my instructions are it was never implemented at all. It was never implemented at all.
So the presence of Mana scheme was there in respect of the technical staffs. It is proved. But whether the scheme was ultimately approved or not, that is silent.
Not approved. And
so there must have a memo that it was not approved.
Lordship, the scheme has also not been implemented in the Bose Institute at all. That is what I was.
Yes, I want the memo. What is the decision? Where is the decision that the
Lordship, this is a direction, a resolution that you review it in line with their salary. This was not something to be implemented like the ACP or the vacancy base. This was something you can review it, place it before the governing council, and then this letter dated 1st August 2001 does not go beyond that. At that point of time, this was the situation that you can review it and place before the governing council. Lordship, then thereafter, Lordship, I'll be coming. Then we come to if your Lordships come to page 65, that is the 164th meeting. Lordship will come to Lordship, that is, it starts from page 61, Lordship. Point 11. And Lordship, Lordships have found it?
Yes.
Lordship. Now, Lordship.
64th meeting.
64th meeting. held on 28th March 2004.
Yes.
And agenda item 164.11, approval of non-academic promotion to Bose Institute. Now, the director apprised the House in the 163rd meeting. The matter of promotion was placed in detail with the advance copy to DST for approval. Bose Institute non-academic staff do not have a well-defined promotion scheme. However, after several years of discussion, the DST finally recommended 3 promotional modes: vacancy-based, ACP, and promotion of technical staff. Lordship, what is being interpreted as recommended was you review it.
You
It's
are
the pay
reading.
scale.
You are reading page
65, Lordship.
65.
It's internal page 5 of the minutes.
Internal page 5. Yes. Promotional scheme.
Yes, Lordship. Lordship.
Yes.
So now the minutes record that promotion, but it was not a promotion in the, I mean, if your Lordship goes back to the memo dated 2001, it was you could review it. They did not give an approval. Review it in terms of the pay scales, give it a thought. But then it was asked, the approval was not there. Therefore, Lordship, in considering
It was also mentioned about the promotion of technical staff on the pattern of money.
Lordship, I shall come to that. Lordship, we have to, in consideration of the long pending cases, the director allowed only those cases who did not get any promotion, only 1 promotion during their uninterrupted service by the duly constituted assessment committee. The total number of recommended cases was 47. DST, after due process of examination, apparently cleared 34 cases, but expressed reservation 13 cases. It was mentioned, Lordship, no formal approval of the above cases was received by the DST. So whatever the minutes reveal, no formal approval of the cases were received by the DST. And no objection was raised either. So if here the DST cannot do it unless the Ministry of Finance gives them the rubber stamp. So simply because there was no objection, it cannot be construed that Maunata Sammatir Lokhan.
No, so there must have a
Because the
specific memo.
DST Lordship will kindly remember the transaction of business rules, under the transaction of business rules, DST is not the authority. These institutions are under DST, but the financial implications will have to go to the Ministry of Finance and then it has to come back. So the DST may not have objected, but there is no approval. So it is.
Issue is that it is maybe case of 50% funding or otherwise. The 100% funding is there. That's why each and every month the funding is coming from the central government, from the Department of Finance.
I shall be placing.
That this is the finance.
I shall be placing, Lordship, how the
look the list there at page 65. Technical mana scheme of CSR.
Lordship,
10 number of employees, no objection of DST.
Lordship, I shall, this is no formal approval, formal approval.
But no objection is also there.
Lordship, as I say that, how can there is no object? Because until and unless the Ministry of Finance gives approval or doesn't give approval, DST is not the authority. DST has to send it to the ministry.
I understand. DST is the administrative.
Yes. So it is routed through the DST, then it has to go to the finance, and then it has to come back. So DST may not be in a position to object, Lordship. That has to come when it's from there, it can come. Otherwise,
no,
Lordship,
after 20 and 30 years, the finance department also cannot say, I am giving the benefit. Thereafter, again after 20 years, it is not correct.
Lordship, they were giving the Lordship, if they were giving the benefit, Lordship, the fund, I shall be placing how the funds are
allocating. How the funds are allocated.
Yes, Lordship. I shall be showing
entire funds are allocating to the DST for the purpose of the other
the
aid and the head of the
funds to the Autonomous Institute according to their that my learned friend shall be satisfying your Lordship how the grant in aid is received. How it is received, and now, Lordship, let me explain. There has been changes in the rule. Now, each year, the autonomous institutions have to sign a memorandum of understanding. And so they have, I mean, what was very loose, there is no doubt about that. We are streamlining it. Things, because this is where we have taken steps to rectify what was going on and on. Yes, I agree. But just because it was going on, it doesn't mean it
Cannot be allowed or cannot be corrected.
Once it is detected, once it is found out, then we have to place matters. After all, Lordship, the fund is public exchequer. The normal procedure, the budget is given and the funds are allocated. My learned friend will give in the details of how it is done. But just because something is going wrong for 20 years or 30 years cannot mean that it can never be rectified, especially when we are dealing with public funds. Lordship, therefore, Lordship, then, so Lordship will kindly come to page 67 then, what I was submitting. That mana scheme, what I was submitting. After discussion, Lordships have found it?
Page 67.
Yes. From the top, after discussion of all the promotional issues at length, the council noted that the institute has not yet reviewed the promotion policy of the non-academic staff as communicated by the DST via the letter dated 1/8/2001 in the light of the guidelines therein. Therefore, Lordship, manner scheme was lying. The guidelines as per letter dated, the council had not reviewed. The council thereafter the council forms a committee to review the guideline of non-promotional staff, the 2001 letter, where the guideline was to be reviewed. The committee, the council in 2004 is forming a committee to review the guidelines. And again, what the resolutions are, the recommendations of the incumbents of the manner scheme may be reviewed by the above mentioned committee. So what was to be reviewed in 2001 was not reviewed. Then comes 2004. Then it is found that no review has been done. Now a committee has been formed to review the guidelines. So manner scheme in Bose Institute was absolutely under the review phase, whether it and my instructions are manner scheme has not been approved at all. And even Lordship, I had shown the memorandum that the annexure of the manner scheme, there it says it's stated it's kept in abeyance. I had pointed out to your Lordships on the previous occasion. I'll just point it out again. That document itself says it's been kept in abeyance, Lordship. So even though it has been annexed, Lordship, just to Lordships would just come to page 60 for a moment. Page 60, Lordship. 60. Lordship, this is that
mana scheme.
Yes, the merit assessments on the left side, Lordship. The merit assessment scheme has been kept in abeyance by CSIR letter number so and so. So this scheme, Lordship, sees they asked us to Bose Institute was asked to just see if it could be done. They did not review. 4 years later, the council admits there has been no review. A committee is being set up for reviewing the manner scheme. This is how the manner scheme is going. And I was seeking instructions, Lordship. My learned friend will be able to satisfy that the service books don't reveal that any promotion has been made under the manner scheme, Lordship. Lordship, thereafter, Lordship, so after 2000, age of contrary. ওটা compilation না না Lordship, Lordship,
Yes.
Lordship, if your Lordships could kindly come to the compilation in Anandamayada's case, the petitioners had given a compilation of documents, Lordship. That was the এইটা ওই যে যেটা স্পাইরাল করা আছে না একটা কম্পাইলেশন, হ্যাঁ স্পাইরালটা। মাথা খারাপ করে আমি বললাম মাথা খারাপ করে দিল।
Yes.
Lordship has come to page 32 of the compilation.
January 2008, page 32.
Yes, Lordship. Now, Lordship sees agenda number 2. There, Lordship, we find, as I had stated earlier, Lordship, consideration for the implementation of pay scales at par with those in vogue in IACS. Lordship, now the scene shifts to IACS. The Finance Committee went over to recapitulate the brief discussions it had taken by the Office Memorandum 8th August 1979. Lordship, if you're this is with when it was at par with the Calcutta University, where IACS and Bose Institute should have been at par. That is the memo that is being referred to.
79 memo.
79 memo. After a thorough discussion in the issue again, the Finance Committee was of the opinion that so long as the letter from the DST was in force, that letter from DST in force, the parity between the Bose Institute and IACS in terms of pay scales and other benefits in respect of non-academic employees should be maintained and enforced. Under the circumstances, the Finance Committee felt that was presently no scope of any further discussions by any empowered committee on this issue. It resolved to communicate this view to the Council of the Bose Institute at the earliest. Therefore, Lordship sees it was still Mana scheme review stage, right up to I have placed the minutes. It was to be reviewed. A committee has been formed. Now, Lordship, we find if you Lordship will kindly come to the very now Lordship will kindly come to the next page, page 34.
As the DST memo dated memo of 79 is still in force, they are going to allow the scheme.
That is their
their agenda. That is the agenda.
That is their agenda. And I had placed you before Lordship, that was 1979.
So far as
At
1979 memo is concerned, it is now in force. So we are going to
because and if your Lordship recall, that was with Calcutta University.
Yes.
That was with Calcutta University. No, ঠিক আছে বলতে পারি। Pay scales relating to Calcutta University.
And here the Bose Institute with at par with the IACS.
Yes, Lordship. So now the question comes in, as I had said earlier, Lordship, now we shift again back to ISCS. Bose Institute has shifted back. CSIR, no review, I've shown your Lordships, for the throughout, there has been, it was sent up for review, for approval, to take the pay scales, parity, everything. Nothing was done. Finance committee, nothing. Now in 2008, Bose Institute goes back to ISCS, not
At par with
at
ISCS.
par with ISCS. Now, Lordship will see that page, the next agenda, page 41, yes. As the council noted the consideration and approval of the minutes of the finance committee held on 7 January 2008 and 31st January 2008. Lordship, I had placed the meeting of 31st January 2008. Now, Lordship, here it says that the chairman agreed that there should be parity with ISCS and Bose Institute in terms of the pay structure and other benefits of the staff, as indicated in the letter from Professor M.G.K. Menon, Government of India. Dr. Ramaswamy, in his capacity as Secretary DST, informed the Council that not only should there be parity between ISCS and Bose Institute.
You are reading page?
Lordship, page 41. 41 is there? No, compilation. Eta kontare dandik badik ki ache?
Yes, page 41.
Lordship found it?
That is the impugned memo.
No, no. Lordship.
8th of April.
No. Lordship, am I? No, I'm looking from the spiral. Yes.
Yes.
Page milche na?
Page 40.
No. Page 41 is there are two markings.
On the right, there is a marking.
আমাদের যেটা দিয়েছে সেটা
In the middle of that marking, page 40.
No, you are reading memo dated?
No, I'm not. I'm reading the minutes, Lordship.
May I just find out?
Lordship, the minutes of the 170th meeting, dated 21st March. Lordship had found it. Annexure C34.
C34.
34, Lordship?
It is at page.
But it is at page 38.
34th.
And there is.
Very, I have found it.
Lordship.
No issue.
Lordship will kindly come to, I think, Lordship, page 37 or 3 pages later. At agenda number 170.4.
170.4. 170.4. Yes. 170.4.
Yes. Lordship.
Got it.
Page. Lordship. Consideration and approval of the minutes of the Finance Committee.
Yes.
The Council noted the minutes of the meetings of the Finance Committee held on 7 January 2008 and the extraordinary meeting of the Finance Committee held on 31st January 2008 respectively, and approved the same following observation on line 2 of the meeting held on 31st January. The chairman agreed that there should be parity between ISCS and Bose Institute in terms of the pay structure and other benefits of the staff, as indicated in the letter from Professor M.G.K. Menon, the then Secretary. Dr. Ramaswamy, in his capacity as Secretary DST, Government of India, informed the Council that not only should there be parity between ISCS and Bose Institute, but among all the autonomous institutes of the Ministry of Science and Technology. He assured the Council that such measures were already underway at the level of the ministry and would be implemented with the proper approval at the earliest. Therefore, Lordship, yes, parity, yes, there is no dispute. But how that parity comes, Lordship, it has to come with the proper approval. How that parity will be maintained. He assured the Council that such measures were already underway at the level of the ministry and would be implemented with proper approval at the earliest. So, a parity of pay scales.
Parity of pay scales of Bose Institute and
ISCS
ISCS
was
is on all the autonomous bodies
everything
under the DST.
There can be no dispute regarding parity of pay scales. There should be. And therefore, but it was, if we go back to it was at the level of the ministry, Lordship, the transaction of business rules I shall be handing over in my compilation, that the two ministries have to consult.
Yes.
So, and the Ministry of Finance is the authority, as in all established. Lordship, the finance has to give the final call to the expenditure, Lordship. So this is now, so till 2008, Lordship, what is being explained to your Lordships regarding the Mana scheme, Lordship, that was not there. Till 2008, the government had approved promotion, either vacancy-based promotion or through ACP, MACP. Mana scheme was never approved. In fact, Lordship, I have received a communication which my learned friend had handed over regarding no approval of the Mana scheme at any point, Lordship. Now, so thereafter, Lordship, so when we come to the impugned memos, Lordship, we come straight to 2008. That was in January, when the question of parity with ISCS comes up. Now there is no, now ISCS comes into the picture. Letter referred to is 1979. ISCS comes in. Thereafter, Lordship, after this meeting, then Lordship will kindly see this. This was also reviewed July 7th and 8th. Lordship, page 71 is the recommendation of the Structural Reforms Committee, which has been referred to in the minutes of the General Council, which I had placed before your Lordship. This was there. Then we come to 2008 Bose Institute. This is Lordship, page 72. Now,
page 72 of the compilation?
No, the writ petition.
Writ petition.
Annexure P6. So, Lordship sees that after this council meeting, we have to, when the question of parity of with Bose Institute comes in, Lordship, with ISCS comes in, Lordship. Now, an emergency meeting of all the academic heads of academic departments were called. And
April 8 to 2008.
This is April 8, 2008.
Yes.
Now, Lordship, the director informed the House that non-academic employees of the Institute, both administrative and technical, had met him on the 4th of April and expressed their deep concern for non-implementation of the revised pay structure and career advancement scheme in the Institute, while those benefits had already been implemented both in ISCS and SN Bose National Center for Basic Sciences. The employees also appealed to the director to implement provisionally. Lordship, kindly note these words.
Yes.
Those benefits that had already been implemented in the ISCS and the SN Bose National Center for Basic Sciences on the basis of the memorandum of Professor M.G.K. Menon. Lordship, that memorandum, first 1979 was also, Lordship sees copy to ISCS was also Director ISCS. They both, the Employees Association and the Employee Staff Unit, have agreed in writing that in the event the DST is in a position to chalk out a formula for bringing parity with the DST-aided institutions, and it is observed that the employees of the ISCS SN Bose National Center are required to pay overdrawn amount, if any, we shall also remain agreeable to make refund thereof in any manner. So they have agreed.
Yes.
Lordship, I shall be placing from my affidavit that ISCS had also gone through there was a group of officers for the IACS, and IACS pay scales, there is a parity now, Lordship. They have been brought to where they actually should have been. So that parity has been established, Lordship. Lordship, then Lordship will kindly see 73. It's read that thereafter he informed in the council that approval of the structural held on 11/4 approved the meeting of the report of the structural reforms committee, but the report was still under the consideration of the DST government of India, not approved. The structural reforms committee, Lordship, I had placed where they say they should be at par with IACS. That was not approved. The issue was again considered on the 169th meeting, where the council approved the flexible component system for the academic staff only. We are not. Then in absence, Lordship, I'm skipping the next paragraph. In absence of the any response from the DST government of India, even after constant persuasion, the office memorandum of Professor M.G.K. Menon, the then Secretary DST, was placed in the Finance Committee meeting held on 7 January, and the Finance Committee considered the office memorandum, fixed an extraordinary meeting on 31st of January. The Finance Committee, in the meeting held on 31st January, discussed the contents of the memorandum at length and recommended there is no scope for any further discussion by an empowered committee. Accordingly, the council meeting of the council was arranged, but the fact remains that the actual approval from the competent authority, that being the Ministry of Finance, has not come. The recommendation, we were all waiting. Everybody was, yes, pay scales may be something that make people very impatient. But in the absence of these recommendations, Lordship, nothing really remains. Accordingly, a meeting, Lordship, then, however, again, Dr. Ramaswamy is being quoted, which I had placed, the minutes I have placed, that informed the council not only should be parity, but again, I stress the point that the measures were underway at the level of the ministry and would be implemented. So, DST had moved at the ministerial level, but it was still awaiting approval. Although then Lordship, two of the heads of the departments expressed verbally their reservation for the issue of such order without absolute approval of the council. However, the House felt that unless the scheme is implemented, even if provisionally, it would be impossible to maintain peace and harmony with the institute. It was thus agreed. Lordship, this was my learning. Lordship, Lordship, this is, I'm just starting from the top. So the director also read out the contents of the office memorandum of Professor M.G.K. Menon. Thereafter sought opinion for implementing revised pay structure, career advancement scheme for the non-academic staff, provisionally with effect from 22/12/2005. IACS date, Lordship, if your Lordship remember. So, the office memorandum dated of 1979, Lordship, this is where they are drawing parity, and sought for opinion for revised pay structure, career advancement scheme for the non-academic staff, institute provisionally with effect from 22/12. That is what the memo of 8/4 had implemented, keeping parity between IACS and Bose Institute as per the decision. There was reservations in the Finance Committee itself, but but then it could be implemented even provisionally if possible, alias, and it would be possible to maintain peace and harmony with the institute. It was thus agreed to implement the benefits in the institute exactly at par with those of IACS, subject to the condition that overpayment, if any, is thereby made consequent to the otherwise decision of the council would be recovered from the employees in a suitable manner. And this was, therefore, Lordship. And it was further stated that it was given prospective effect and retrospective effect will be given after approval. So, Lordship, when the scheme, the two memos, and on that very date, we find memo dated 8th of April, the impugned memos, Lordship, April 8, 2008, which itself, Lordship, reveals that there was no approval from any quarters. The minutes show it. On the same day, the memo is being issued. And there was no approval from the competent authority regarding the scheme. Lordship, I'll just place in anticipation. Lordship will kindly come to page 76. I had placed that. Lordship says, in pursuance of, I'm just reading a few lines, in anticipation of formal approval. Regarding parity between Bose Institute, IACS and other institutes, the Director Bose Institute, having been satisfied that the revised pay structure and career advance scheme was implemented in Indian Association for Cultivation of Science with effect from 22nd of December 2005, and on recommendation of the meeting of the heads held on 8/4, that is the previous minutes that I placed, we are pleased to implement the identical revised pay structure and career advance scheme. This is how provision of the non-academic staff of the institute provisionally, with effect from the same date, for keeping parity with Bose Institute and IACS, subject to the conditions that overpayment, if any, thereby consequent to an otherwise decision of the competent authority, shall be recovered from the employees in a suitable way. So there was always a risk of the scheme going beyond what it should. So, and it was started on the basis of the undertaking that we will return if the competent authority states otherwise. And the revised pay structure was launched, memo dated 8th of April, and thereafter the entire pay structure, the tabulation dated 15th April, Lordship. And these two are the impugned memos that have been struck down. Lordship will kindly come. I shall just. Before Lordship sees that.
Yes.
Lordship. So the promotional policy under the MANA scheme not reviewed. DST at par, Lordship, they were trying to bring in, but they were consciously aware of the fact that this scheme has got no approval, Lordship. And knowing fully well, in fact, they had informed all the stakeholders, the employees' unions, everybody who had come to meet, that it would be provisional. And they gave the undertaking that if the pay scales are more, if we are getting higher emoluments, then we will be bound to return. So the entire scheme had started on a background of uncertainty, background of knowing that it was not approved. When, Lordship, the rules require to implement the scheme after approval from the competent authority. And here, Lordship, throughout we have seen that here it says it is admitted that there is no approval of the competent authority. Yet the pay scales were implemented, Lordship.
So what is the rule for the promotion of the scientists? All the CAS and MSCP and the
Lordship, scientists we are not academic staff is not under consideration here, Lordship.
No, the MANA scheme is respect of the scientists, meritorious scientists.
Lordship, that is in respect of the
meritorious
scientists, Lordship.
Yes.
Lordship, from the document that we find, it was in respect of scientists.
No, there is no such scheme with the central government.
There is no such scheme with the government. Lordship, it is not a government scheme either. That scheme, as we found, was placed by the I mean, it was a CSIR scheme, but that also did not have any approval. Because now that annexure is for the scientists. Then that is, yes, scientists, the Lordship, the scientist scheme for the scientists are that component, flexible component scheme. Flexible complementing scheme. That is for the scientists, that is approved by the DOPT. So that is not an issue here, Lordship. So therefore, Lordship, in my affidavit in opposition, Lordship, I had also just like ISK's taken to the ওটাকে তুই details আমি এখান থেকে Lordship, just
Your affidavit?
My affidavit, the Government of India's affidavit. Lordship.
Yes.
Lordship, page 5.
Page 5.
Subpara 6. In compliance of the above instructions of the central government, while extending the benefits of the 7th Central Pay Commission to the employees of Bose Institute and other autonomous institutes under the department, it was found that similar time-bound promotion schemes for technical and administrative staff have been implemented in Bose Institute, Indian Association of Cultivation of Science, IACS, and the National Academy of Sciences, India, without any approval of the central government. The group of officers had deliberated on the issue in detail. Based on the findings of the group of officers, a decision for revocation of the irregular promotion schemes covering the technical administrative cadre were taken in these 3 institutes. So, Lordship, it is not that Bose Institute has been singled out. Prior to implementation of the 7 CPC, Lordship, I had placed that memo. Group of officers were formed in various autonomous institutes, and at the time of affirming this affidavit, Lordship,
They found that not only the Bose Institute, but also
yes,
other 2 institutes also.
In fact, Lordship, lower
time-bound promotion scheme.
They were also brought to the place where they actually belong. I won't use the word down, but I'll say to where they actually belong, Lordship. 3 institutes. So it's not that there is anybody's being singled out. In fact, Lordship, this affidavit has been affirmed in the year 2020. Lower down, we find that identification of other institutions where such irregular financial upgradation promotion is made without any vacancy in respect of technical and administrative cadre is also underway, and then similar decisions will be come. So 3 were done at the time of swearing this affidavit. More were under process, Lordship. So this is where the Government of India has actually taken things to task. Maybe after long years, yes, Lordship, that I must admit, but we have started. So what now I can say that Bose Institute and IACS may be at par legally. Whatever they are getting, whatever pay scales they are enjoying now, are being given with the approval of the competent authority.
Yes.
So this is what they are enjoying, Lordship. Now they are truly at par, Lordship. Correctly, truly, legally at par, Lordship. Lordship, from your Lordship's queries, Lordship, just to Lordship, the queries were regarding any specific guidelines in respect of career advancement schemes. Lordship, I have stated that the service condition, Lordship, I had started my submissions with, I had placed the general financial rules which govern all autonomous institutions. So they are bound by the general finance. They cannot go beyond what is approved by the government. Timescale promotion, Lordship, there was no approval, Lordship. That is, I have
Yes.
explained that. Lordship, the second query was relating to the Mana scheme, Lordship. That I have shown your Lordships from the various minutes of the various meetings, the letter which they had claimed that Mana scheme was approved, but actually Mana scheme was something which was to be reviewed. So that was, and the government of India, the DST has informed that there was no approval of the Mana scheme. Lordship, the timeline promotions, Lordship, was stopped by the memo dated 16th of October, Lordship, where all these impugned memos which are without any approval from the central government, Lordship. They were issued, in fact, admitting that there is no approval. Now, these memos where these timescale promotions were given, promotions were normally under the ACP MACP scheme, where it's three times a year if it's an institute promotion. Here it's gone up to 7, 8, according to. So that GO has stopped, Lordship. A query has been asked, your Lordship said placed regarding disbursement of grant and aid, how it is done, Lordship. I humbly submit, we are not in the micromanagement. So I think my learned friend will be able to explain how the grant and aid is. But grant and aid is given. So whether, we had, the pay scales, it was, the grant and aid comes as a whole under various heads as they ask for it, Lordship. My learned friend will be able to explain that.
Okay.
So, Lordship, the question was regarding timescale promotion. Lordship, formally, the memo dated 16th of October, where the two memos of timescale promotion, 8th April 2008 and 15th April, where 2008 was struck down as null and void. So, Lordship, a question had come up regarding who is a competent authority. At this stage, Lordship, I don't think there is, any doubt it should be, but there are, I'll just, your Lordship comes to the compilation again. There is a, directed the powers to the 27 January. Lordship, there is a memo issued. Lordship, page 2A is the typed version.
You are referring the compilation?
In the compilation, it was not in the annexure, Lordship, it's in the compilation.
Page?
Page 2A is the type, the more legible copy, 2A. Right? Lordship will find it's a memo. It's a memo dated 27th of January, 1999. Office Memorandum, Guidelines for Enhancement.
27th January 1999.
Yes, Lordship. Now, Guidelines for Enhancement of Functional Autonomy of Research and Development Autonomous Institutions under S&T, Science and Technology Department's institutions. So, Lordship will kindly come to the financial powers.
Yes.
In accordance with Rule 13(2) of the Delegation of Financial Powers rules, a department or central government can confer powers not exceeding those vested in the department upon an administrator or head of the department or any other subordinate authority in respect of matters covered by these rules. On the analogy of the above rules, the governing councils, governing bodies may exercise powers up to the limit of powers enjoyed by the administrative ministry, except, Lordship, creation of posts, which has been done here, writing off losses, reappropriation of exceeding 10% original budget. The exercise of enhanced financial powers by the governing council's bodies would be subject to the provisions of general financial rules. Restrictions on DFPRs and other instructions, orders now in force or to be amended, issued by the central government from time to time. The powers are there, but they have to be bound by the rules. Will be subject to the provisions of the general financial rules. And the general financial rules, I had pointed out to your lordships, that the pay scales cannot be more. They cannot enjoy pay scales more than the central government employees. Lordship, so even though the directors of autonomous bodies are given powers, that power is not unfettered. So what the governing body had thought that they could adopt schemes, Lordship. Here they are bound by the rules. They are bound by the general financial rules. Transaction of business rules require when two departments are involved. The finance department's consent is a must, Lordship. Therefore, under these circumstances, the competent authority cannot be the director. Ultimately, it has to be the Ministry of Finance, and DST in consultation with the ministry, without the approval of the Ministry of Finance. But now what the petitioners are getting, they have been, lordships have seen that detailed instructions the group of officers had placed, detailed instruction as to how how the entire arrangement is to come about, Lordship. I'll just after declaration of the orders as null and void, Lordship, how the pay scales are to be calculated, how it's to be brought down, and how it's to be calculated, Lordship, all the details have been done. And in my humble submission, what they are enjoying now is what they are actually legally entitled to. We have not reduced, we have not, I mean, it's nothing penal, but one wrong was being committed for a long time, taxing the public exchequer. And Lordship, this is what is, I mean, now they are getting what they should have got, what they're entitled to, Lordship. It is true, I admit that there has been a delay, but we have started with the 7th implementation of 7th Pay Commission. Now they are getting the entire 7th Pay Commission scale. They are getting the benefits of the 7th Pay Commission, Lordship. So that they are getting. And how it has been done. And Lordship, we find that the employees were also informed from time to time. The due dawn statements were sent to them. So for their comments, so they were kept in the loop while this entire exercise was being. Therefore, that Lordship, this is my submissions relating to the general
I understand.
lordship. Oh, Lordship, there's just thank. Lordship, there was another query regarding the minutes of the group of officers, how it was deliberated. Can be done a compilation 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 can theta but আমার কাছে নেই compilation 95 page 95 এটা অনেক পরিষ্কার আর আগে 95 হ্যাঁ আচ্ছা কালকে রাতে এটা দেখেই তো this my Lordship, page 95 of the compilation contains the Lordship, would I Lordships trouble your Lordships to take out CAN 3? That document is much more legible than the document.
CAN 3?
Yes, because it is in the compilation, Lordship, but the annexure in the compilation is not very legible. CAN 3,
Old CAN 3651.
CAN 3651.
Yes, can give me the number, page number at CAN 3?
Page 79, Lordship.
Page 79. In CAN 379 is one of the petitions.
Lordship.
CAN 3651.
CAN number 3460. No, that is Greek number. CAN 3 of 2021.
Tell me the page number of compilation.
Compilation page number 95.
94.
94 is the RTI, yes. 95, it starts from 95.
95.
Yes.
Yes, it is readable.
Lordship is very readable. Oh, mine is not. Lordship will kindly come to paragraph 3.
No, what is this? Group of officers?
Yes, Lordship. After Lordships, remember they were asked to give documents, the chronological
compilations.
And Lordship will kindly find that if we come to page 96, paragraph 10 is all the documents that Bose Institute had.
Yes.
Bose Institute had file documents. 8. No. Lordship will kindly come to paragraph 12. Yes, Lordship, page 96, paragraph 12, by its letter dated 15th of July, Lordship, furnish detailed chronology of events, Lordship. Bose Institute furnishes. So that comes, this is paragraph 12. Then, Lordship, Geo found that some submissions were without. So Lordship sees that initially what was given, Lordship, the Geo had found that the submissions were without any supporting documents. Hence, I'm reading from paragraph 11, Lordship.
Yes.
Hence, it was suggested that BI should furnish DST within 3 weeks a chronology of events. Lordship, recall that they had asked for the chronology of events. Paragraph 12 is on 16th of July. They filed the chronology of events and the copy is there, including Yes, the last entry is post pay scales, etc., showing Bose Institute vis-a-vis DRDO. In addition to the submission made, then paragraph 13 onwards, the GO thought it prudent to consider as to whether the adoption of timescale promotion in lieu of vacancy dated after by its OM was implemented with the approval of the competent authority as contested by BI. Because BI, yes, this is what Lordship I had stated, that the timescale promotions, Lordship, were without any approval from any competent authority. So the documents records available to the GO, the contention of Bose Institute having having placed reliance on earlier OM dated 8th of August, the governing council had accorded approval of pay parity. This is, Lordship, the sequence that I had shown your Lordships. It was found to be factually incorrect. The minutes recorded on the agenda 170.4 of the GC meeting dated 21st of March 2008 is reproduced below. Lordship, this is where the parity it comes in, Lordship. These were all placed, Lordship. So then, Lordship, then the minutes signed under the signature of Dr. Ramaswamy categorically states that the measures were underway and would be implemented with proper approval of the earliest. The following three conclusions may be drawn. OM dated 8th of 79 was not enforceable so far as parity of pay and allowances of exclusive ISCS and Bose Institute employees were concerned. Prior approval of competent authority, namely DOPT and the Department of Expenditure, was required for granting parity of pay and allowances and other benefits amongst all AIs. ISCS case was not having proper approval of competent authority, and their entire whatever was placed on the basis of ISCS. So, Lordship, then the 8th of memo, Lordship, that we have, and Lordship, paragraph 18, I'll just pause. It is worth mentioning that the transaction of business rules, Government of India, Rule 4, Sub-Rule 1 and 2 states that when the subject of a case concerns more than one department, no decision be taken or order issued until all such departments have concurred, or failing such concurrence, a decision thereon has been taken by or under the authority of the Cabinet, Lordship. Then, Lordship, 17. Achha.
No, in respect of more than one department is concerned.
Yes. Here, Lordship,
of the same decision, if is required, then the cabinet approval is required.
Lordship, 17 is also, Lordship, how the Bose Institute had drawn the two memos were illegal and Lordship, paragraph 17, I'm just browsing through it for a minute. The two memos were illegal and arbitrary for being issued by BI authorities in gross violation of the prevailing GOI rules, provisions, and in utter disregard of the directions of the General Counsel, Chairman, Secretary, DST, contained in the minutes dated 21st of March 2008. That is the previous minute that has been quoted, that it is being moved for approval. The usage of the phrase having been satisfied in the OM dated 8th of April by subordinate authorities smacks of gross insubordination. The said illegal and arbitrary orders were passed with the clear intent of drawing higher pay and allowances and other benefits than that admissible to corresponding central government employees. So it was set aside. Why those memos were set aside, Lordship? And then the group of officers had given detailed how the statements were to be drawn up, sent to the competent authority for approval, and the competent authority has given its stamp of approval, whereby by the impugned memo dated 16th of October 2019, the two memos were set aside. They came to the finance too, huh? Okay, for the last year. Lordship will kindly come to page 100. Your Lordship is seeing the compilation.
Yes.
Page 100 is last Lordship paragraph 13 subpara XIII. A copy of the report along with documents may be forwarded to the Ministry of Finance for perusal and information. So everything was sent to the Ministry of Finance. And memo dated 1610 was issued with the approval of the competent authority or the Ministry of Finance.
Yes.
Lordship. Lordship, I have covered the Government of India's submission stand in respect of.
So you have prepared the compilation.
Lordship, I shall be preparing. I'm still in a mess, Lordship. I shall give it to your Lordships.
So one matter is there regarding the pensioners.
Lordship, that is much lower down in the list, Lordship. That they will. That is I think 140.
Okay. So we have prepared the Bose Institute.
The Bose Institute will have to start now.
Yes.
Lordship, under a compelling circumstances, may I be permitted to mention one matter, Lordship? Item number 169 for taking out of turn.
Okay. Just,
I will inform the others.
okay. Just let me.
Kindly fix it, subject to your Lordship's time convenience. I'll give this time because I need some time to argue. It's a very complex matter.
Not complex matter. You have made it complex. No one.
Yes. An item number.
Therefore, he should be given time.
Actually, Bose Institute made it complex. Otherwise,
That we all agree.
The entire scenario has become complex because of.
no, this side I have some problem. I have to go to Jalpaiguri.
For the next 2 weeks.
Next 2 weeks.
Item number.
That is, otherwise this matter could be concluded before the vacation. It would be better for me also. I am in the session of this matter. That's why I wanted to destroy this matter first. There are several employees suffering. So 6th or 7th of November.
7th, your Lordship said fixed.
7th of November is the only date.
Yes.
No, Lordships have already. No.
No,
7th, your
6th.
Lordship said fixed one Bose Institute matter also. So, yeah, but this can continue. That can start later.
On the 6th.
Or 8th. 6th, I have fixed matter of group 8.
Lordship can fix it on the 7th because that another matter would be starting. So I think this can be over and then
Concluded, my lord, it would be easier for us also, my lord, to address your Lordship, my lord,
yes,
regarding the other matters.
Let it be.
Yes, it has to be.
Yes,
it has to be concluded first.
Let this be on the 7th, Lordship. Your Lordship had fixed, I think, Ongshuman. There is another matter, I think.
Yes,
Lordship
Mr. Chakraborty is there.
Mr. Arunabha Ghosh is there.
Oh, no, yes.
Lordship, we should.
If
Mr. Chakraborty.
we should call the
Yes.
finish tomorrow itself.
Lordship.
He is in a hurry, my lord, I do not understand. We are petition, we are suffering, that's the one.
No, tomorrow I have some fixed matters. Whatever maybe. Please take down. Argument on behalf of the Union of India concludes. Let the matter fixed for further argument on behalf of the Bose Institute on 7th of November.
It will be my lord's pleasure to fix any subject.
As a pattern matter. As a pattern matter, it will appear on top.
Retain its position, yes.
It will appear on top.
Lordship.
Lordship, in item number 18, Lordship, there is some difficulties. The authority is going to fill up the vacancy. Similar type order is required to be passed, what has passed by your lordship. Group 8 matter, lordship. Other side has come, lordship. Lordship, I have bring them, lordship. Your lordship will not available from the next 2 weeks, lordship. That's why I'm item number 18, lordship.
No, today I don't have the determination of item number 18. I have group 6 matters today.
If you lordship kindly take up the matter tomorrow, lordship, as to be mentioned. Similar type of order.
Tomorrow all the group 6 matters are there.
Your lordship can understand our difficulty because we will not get your lordship
Then
from the.
you to come on 7th of October. 7th and 8th.
Because the MAT 1543, the interim order is substituting till lordship 30th September.
30th September.
30th September. Your lordship has similar type of order. You will, if you lordship kindly take the matter to be mentioned, will lordship serve notice upon him, lordship, as the state is here.
I'm for the state.
Who is for the state?
I'm for the state.
What is the matter?
The lordship, the ration dealership, lordship.
No,
in
group 8 matters I understand. Item number
18 of today's list, lordship.
Item that is a new motion matter.
New motion, lordship.
Then come on tomorrow. Item number 18. No, new mention matter only this matter. Only this matter. Item number 18. Mention matter.
Grateful.
Lordship, item number 169 can be.
Yes. Yes, Mr. Mukherjee.
Item number 169, Lordship.
Yes.
Of today's list, Lordship. Hearing matter, Lordship, can it be taken up out of town? I will inform the Union of India.
(169).
Yes, Lordship.
Prahlad Kumar.
Prahlad Kumar.
What happened here? The your client is now
Yes,
there.
they are coming from Patna.
Yes. Your client mention it at the earliest. So what is the matter here?
Service matter. Lordship.
Service matter? The service has been
terminated. Yes.
Due to some
Due to proceeding of a criminal proceeding.
okay, due to the criminal proceeding.
Yes,
What
I have
happened
been
now?
acquitted,
Criminal proceeding acquitted.
Acquitted.
Then come on tomorrow.
2 weeks. Tomorrow, Lordship, no problem.
Tomorrow?
Because the next 2 weeks, Lordship will not be
Yes.
available.
Tomorrow, let's see whether it can be disposed of. Please take down. On mentioning the item, this matter, item number 69, 169. Be upgraded within first 3 matters. Tomorrow's list.
Deeply organized.
Today second half. Okay, today original side is there. Otherwise, it can be taken today. Okay, original side matters is there, so it will be remain in the list. Likewise, tomorrow it will appear. Let them come. Let them come. Otherwise, it would be let them come.
My lord,
Okay.
next matter was supposed to be taken up. Next matter was mine, my lord. Next matter was
Your matter, item number
138. My lord, next matter was supposed to be taken up, my lord. It was on being mentioned, it has been upgraded within 5 matters on my lord. On 3rd of September, my lord, it was mentioned.
Then come on tomorrow then.
Yes.
Tomorrow it will be remain in the list, no issue. Tomorrow, if we can take it, we can dispose of it.
If it can be
Further upgradation? No. Okay.
এই যে
I appear for the petitioner in this matter.
Yes.
There is also an appellate side writ, my lord, in which my learned friend is leading, my lord. He'll start first, my lord, then I'll.
You are the petitioner of the writ petition,
The original side, my lord.
original side.
Yes, my lord.
And
I appear for the petitioner and
In
I'm
the
led by Mr. Abhijit
appellate
Mitra,
side.
in the appellate side matter, my lord.
okay, give me the appellate side matter first. And
It's served on everyone.
so you were both in this matter. Appellate side, to.
May I start by filing the affidavit of service and then I'll
Yes.
start. Lord, I'm led by Mr. Abhijit Mitra. My lord, I will start because there is some urgency in the matter. My lord, before I get into the merits of this matter per se,
Yes.
perhaps it is necessary, lordship, to give a very brief overview as to what this matter is really about, the subject matter. My lord, the subject matter of this writ petition is really the survival of the jute industry as a whole. Now, lordship knows that the jute industry occupies a very special position in India. It is an industry which is labor intensive. In other words, lordship, what is required to make this industry function is a
Yes.
In other words, lordship, this industry survives on the participation of lakhs and lakhs of people, which is why it is called a labor intensive industry. Lordship will appreciate that most of the jute mills in India are concentrated in the state of West Bengal, and Lordship will see that it is these jute mills which employ the largest number of people, because each of these jute mills required thousands of workers to make the jute industry function. Now, my lord, it is also because it is so important for the livelihoods of lakhs of people, jute as a product, lordship, was categorized as an essential commodity under the Essential Commodities Act. Now, lordship, as opposed to any other commodity, essential commodities also occupy a special place because by virtue of being an essential commodity, they require a very special type of protection and regulation from the state, which is why, lordship, there are these special legislations. What sets jute apart from any other essential commodity as such is that jute is also covered by another special legislation which is only for jute, which is called, lordship, in short, which we call the JPM Act in short, but the full name, lordship, is it's called the Jute Packaging Materials Compulsory Use in Packaging. Oh, sorry, lordship, it is the Jute Packaging Materials Compulsory Use in Packaging Commodities Act 1987. Now, lordship, this will be the bedrock of the case which we will make out, because what lordship will find is that what we have challenged in this writ petition runs contrary to and in violation of all the protections which the jute industry is enjoined by statute to get. What the impugned acts are completely renders all these protections nugatory. Now, lordship, why was the Jute Packaging Material Act, the JPM Act, enacted in the first place, my lord?
Yes.
To appreciate this, my lord, if lordship kindly considers page 59 of the writ petition, that is the typed copy of the statement of objects and reasons for the 1987 Act. That is page 59, lordship, of the
Yes.
writ petition. Lordship. Yes, yes, that's being taken up first.
But because my lord, we have the copy of the original site. We don't have the copy of the FLH site, my lord. Have an extra copy.
You please hand over.
Lordship, we will do so. হ্যাঁ তোমার ব্রিফটা দিও page 59. Huh. Lordship, may I just place this quickly?
Yes.
The jute industry occupies a significant position in the national economy, and more particularly in the economy of the northeastern region of the country. It is agro-based, so agriculture-based, which is again very crucial to the entire country, labor-intensive, export-oriented, and its raw material input base is entirely indigenous. This is another reason for protection of the jute industry, because all the material which is used, exported, it is all produced within India, which is why it augments the national economy.
Yes.
It provides direct livelihood to nearly 4 million rural agricultural families and 2.5 lakhs industrial workers. Now, this lordship is in the year 1987. Nearly 40 years have passed. This number has more than quadrupled. So now it will be in the range of several scores of lakhs whose livelihoods depend on this industry. Now, my lord, paragraph 2. The jute industry has been passing through a severe crisis in recent years, mainly on account of the stiff competition between the jute packaging materials and synthetic substitutes. Lordship will see that jute packaging materials are in any, now with the rise in environmental consciousness, jute is an environmentally friendly material, which is now it needs to see a revival in present day India, because the plastic packaging materials are actually a more environmentally harmful substitute, which is why the importance of jute. Government have recognized the importance of jute industry, and accordingly a number of measures have been taken recently for increasing raw jute productivity, for modernizing of the jute mills, support for the activities of research and development and product diversification in the industry. In addition to these measures, it has also been considered necessary to afford protection to the industry by specifying through legislation the compulsory use of jute packaging material in commodities declared to be essential commodities under the Essential Commodities Act and articles produced in a scheduled industry as defined in the Industries Development and Regulation Act 1951. Now, Lordship will see what this legislation seeks to do. That is paragraph 3. While the legislation seeks to protect the interests of the persons engaged in the raw jute production and jute industry, a balanced view of the recent developments in the national economy has been taken into account. Lordship, I am led by Mr. Abhrojit Mitram.
Yes.
My lord, I'll finish the statement of objects and reasons. As such, it is not proposed to make the packing in jute packaging materials compulsory for all commodities or classes of commodities or their entire production. The legislation itself is of an enabling nature under which the government would issue from time to time notified orders specifying certain commodities, class of commodities or percentage thereof, which should use only jute material in packaging for the distribution or supply of these commodities. My lord, only till this extent, Lordship, I will place. My lord, kindly allow. Lordship, my seniors asked me to continue. But the bill also provides that before the issue of such notified order, it would consider the recommendations of a standing advisory committee, which would give its opinion on the basis of the guidelines included in the legislation itself. It is felt that these guidelines will take care of the interests of the jute economy on the one hand and the needs of the end users on the other. In addition to the above, the bill provides for penalties for contravention of the notified order, power to enter and search and seizure and other necessary provisions. The bill seeks to achieve the above objects. Now, my lord, this legislation itself gives a special protection to the jute industry in order to primarily protect the several lakhs of people whose livelihoods depend solely on this industry. For this reason, Lordship, what was sought to be done by this legislation is that certain classes of commodities
or certain materials would only be packed in jute packaging material. In other words, Lordship, jute bags of varying nature, of varying specifications, which are laid down through the Bureau of Indian Standards. So by law, let's say, Lordship, food grains. Food grains can only be packed in jute bags and in no other kind of bags. Now, this achieves several objects. Not only is it environmentally friendly, it also ensures the sustainability of the jute industry. And what we are concerned with in this writ petition is, really speaking, the price. At what price are these bags to be distributed and sold, and in what manner? Well, now may I leave it, Lordship, to you, because now we'll have to go to the merits of the matter.
More of that seat on the right direction, absolutely. This is what, after the objective, I will tell you briefly what I am trying, how I want to put my case.
Well, the Jute Textile, this compulsory packaging act makes jute a protected item. As in, the jute will be, I will show from the act provisions also, mandatory packaging of food grains and other products, various other products will be in jute bags, for which there is another subordinate legislation brought into effect called Jute Textile Control Order. Time to time, jute is also made an essential commodity under the Essential Commodities Act. It is in the schedule. The Jute Textile Control Order empowers the Jute Commissioner, a very high officer in the Ministry of Textiles, a bureaucrat with powers, firstly, power and obligation, firstly, to implement this act. Well, I missed out one thing. In pursuance of this act, Lordship, the Standing Advisory Committee recommends what quantity should be packed in jute bags and what items.
Yes.
Notifications are made. Notifications also provide that labor laws will be complied with for those applying. Now, Lordship, apropos that, to implement that, there is a Jute Commissioner under the Jute Textile Control Order. In short, we call JTCO. He fixes the price. For the price fixation, the Tariff Commission of India makes a study on a regular basis. And on the basis of the study, it gives its report stating the formula which should be applied to arrive at the price of jute bags, which will depend on various components, raw materials, mainly raw jute, labor, etc. So there are weightages, the whole formula. In fact, we had fought a long drawn litigation, the jute industry to the jute mill, for revising the Tariff Commission price. The pricing formula. Our court directed Tariff Commission to submit its report. It went all the way up to the division bench, and division bench directed Tariff Commission to give the report. Report has been given, and the ministry has accepted a new formula by which the jute mills are notionally provided a nominal profit, 10, 15, 5, 10%, which is available to efficient jute mills. And every month, production control orders are issued by the Jute Commissioner in terms of this act and also the JTCO. These orders state you have to supply to each jute mill, you supply this quantity of raw jute bags to this state body, like Haryana, like Punjab, like different bodies, for them to pack the jute, the grains in jute bags. Now, but there also the price is mentioned because that's derived by the formula. 80% of the jute mills are dependent on this packaging of jute bags against PCOs, PCSO, production control orders, and supply, because the private sector in jute, mainly international, is very small. And the jute industry involves several lakh workers, several lakh jute growers. Workers are the main, and the jute mills employing those workers. So this is how the system functions. Jute Commissioner is given power to ensure that jute mills indulging in unfair practice do not get production control orders. There can be directions made that you are hoarding raw jute. So if you don't do it, I will stop your production control. The intention is not to treat jute industry as any other private sector where the fittest survive, but the workers are employed.
Yes.
The growers get their job. And that is the intention behind this act and the JTCOs, subordinate legislations. That everybody, all the jute mills are provided, and not that out of the 75 jute mills operating, like any other the corporate sector, 7 of them will knock out all the others, mechanize the system, or use imported products and capture the market. That is totally abhorrent to the Jute Packaging Act, your Compulsory Packaging Act, and the JTCO 2016. In fact, recently, this came to notice that a lot of unorganized sector jute mills have come up who are not paying the laborers their due wages under the under the trade-wise settlement. The unions went to the writ court, and in the meantime, the state government made a list of all the errant jute mills, around 11 or 20, 11 or 17, who are not paying their wages, the due wages as per settlement, and asked the Jute Commissioner, you take action against them. Writ petition was filed in the presence of Jute Commissioner. Justice Sarkar passed an order that submit a report, state government, all the errant jute mills for the appropriate action to be taken, which is stop their PCA. So this is the order passed last month. I will show. At this juncture, what has happened is there is a proposal to abandon partly this system and to keep it under this act, keep it essential commodity, keep the Jute Commissioner office, but the jute bags will be purchased not against PCOs, but against e-auction.
E-auction.
Now, we have come up against this primarily on a few statutory, it'll be a violation of the statutory provisions if e-auction. After all, a policy decision cannot be contrary to a statutory provision, number one. Number two, it will go against the ethos of the act, because this will be that the unorganized sector who are not paying the wages of the workers in time and not honoring the trade settlement, for which the union has filed a petition where I'm told Mr. Jointo Mitro is leading. There, that anybody will bid and take it. Unorganized sector will not be able to, we will be able to undercut the organized sector. The object of the act will be lost. Apart from that, there are some super jute mills who have got a very large infrastructure. One of those mega jute mills whose cost of production is lower, very highly mechanized. They'll be able to undercut, and it will throw out many of the jute mills out of business. This is not the object of that. Lordship kindly sees the statutory provisions. Lordship now kindly sees this is the objects and reasons. I will be as brief because Mr. Mitra, I'm told, is stuck. He wanted to do it tomorrow, I'm told, to join the Mitra, because he is stuck in a matter. Because now, Lordship kindly takes a look at the Jute Packaging Act, which is for which the statement of objects and reasons Mr. Sarkar had placed. ওদের দিয়ে জানে সব জানে রাজীব কিন্তু তাও Lordship, the Jute Packaging Act kindly sees section 3. Notwithstanding anything contained in any other law for the time being, the central government may, if it is satisfied after considering the recommendation made to it by the Standing Advisory Committee that it is necessary so to do in the interest of production of raw jute and jute packaging material and of persons engaged in the production thereof, by order published in the official gazette, direct from time to time that such commodity or class of commodities of such percentage thereof as may be specified shall, on and from such date as may be specified in the order, be packed for the purposes of its supply or distribution in such jute packaging material as be specified in the. Kindly come to section 4 now. Four one. The central government shall, with a view to determining the commodity or class of commodities or percentages thereof in respect of which the jute packaging material shall be used in their packing, constitute a standing advisory committee consisting of such persons as have, in the opinion of that government, the necessary expertise to give advice in the matter. 2. The standing advisory committee shall, after considering the following matters, indicate its recommendations to the central government, namely, D. The protection of interests of persons engaged in the jute industry and the production of raw jute, the need for continued maintenance of jute industry, and F. The quantity of commodities which, in its opinion, is likely to be required for packing in jute material. Now this goes on. Now, Lordship, 6 is very important. The central government may by order require any person who is required to use packaging material for packing under section 5 to furnish for the purposes of this act such information in his possession with respect to any commodity or class of commodity or percentage thereof which requires such packing. To any officer specified by it in such form and within such period as may be specified, and the samples of such jute packaging, etc. So the object is that compulsory packaging should be implemented, and it is a protection, that is 4.2D, protection of interests of persons engaged in the jute industry.
Yes.
And the production of raw. Now, Lordship kindly comes to the petition, page 65.
Yes.
Now, Jute Textile Control Order, page 65. This is the Jute Textile Control Order used from time to time. Lordship kindly comes straight away to Regulation 4. Page 66. The Jute Commissioner shall take all steps necessary for the implementation of the Jute Packaging Materials Act. This is that which I was placing, or any other directive of the central government, and may by order direct any jute mill to produce such quantities of such specifications of jute textiles as may be specified in the order for such implementation. And the said order may be called production control order. This is the system which the statute requires. How can they go against it by a policy decision? Now, 2. copy couldn't be copy. The Jute Commissioner shall take all steps necessary for the implementation of the Jute Packaging Materials Compulsory Use Act or any directive of the central government and may by order direct any importer, processor, trader of raw jute and jute textiles to mark or print or brand such quantities of such specifications of jute textiles and may be specified in the order for such implementation. Now, Lordship, there are various other provisions. 5, 6, Jute Commissioner's powers. Jute Commissioner may by order power to for 5, power to regulate stocks of raw jute. Jute Commissioner may by order. 6, power to ensure availability of raw jute with a view to ensuring any easy availability of raw jute. The Jute Commissioner may by order require anything. Then kindly come to 7. 7 is very important. If there is a e-auction, firstly, there will be no PCOs. And then 7, Jute Commissioner may, with a view to ensuring quality of jute textiles in the market and to protect the interest of end users, require any person producing or holding stock of jute textiles or transporting jute textiles to this end user to deliver samples for inspection. Can be to permit any official of the central government or state government or any autonomous or any other autonomous body or institution authorized by the Jute Commissioner to draw such samples. To provide a copy of the inspection report. These are the powers given to the Jute Commissioner. Then 8, power to prohibit supply by manufacturer. Any manufacturer may be prohibited from supplying any jute textiles for a period ranging from 3 months to 2 years, depending on the nature and extent of unfair practices carried on by the manufacturer. These are the checks and balances which are provided in the statute, but Regulation 4 requires procurement. Regulation 4, page 66, require procurement of jute bags through production control orders to be issued by the Jute Commissioner.
Yes.
And that is how the Jute Commissioner also ensures that his power to inspect, see the quality, unfair trade practice. Now, show me that now I wanted to show all that document. Now, Lordship, kindly see a recent order. Direction. That's Aaron Jute Mills direction. A recent order passed on Mr. Jointo Mitro's writ petition in another court. The Union of in the other writ petition by letter they have order a copy. They have by letter disclosed these documents, the union, they're given that they will rely upon it. So that's copy. Kindly see, the issue is with regard to non-compliance of tripartite agreement by some of the jute mills. There is allegation of non-compliance of the order of the Ministry of Textile. The Special Labour Commissioner of West Bengal shall file a report on 17 September upon making a detailed inquiry with regard to the allegations made by the petitioner about some of the jute mills not complying with their obligations under the tripartite agreement. Necessary remedial actions may also be suggested. The report shall contain the names of those jute mills who are found to be deviating from their obligations in the agreement as was found by the state government. The petitioner and the state government shall once again communicate this order to the Jute Commission. It is a written. This is preceded by letters issued by the ministry to the Ministry of Labor here, to the Jute Commissioner pointing out there in jute mills. So the writ petition is filed to direction upon the Jute Commissioner to ensure that only the compliant jute mills get production control orders. I'm just showing the direction. Lordship, now before that, kindly come to the production control orders, page 69. Page 69.
Yes.
70, like these are the production control orders issued by the Jute Commissioner under Lordship says the first line here, I am directed to convey that the Jute Commissioner in exercise of the powers conferred on him by clause 4 of the Jute Textile Control Order 2016. That is the one at page 66.
Yes.
To produce, has directed that you shall produce and deliver stores subject to the terms and conditions specified here. So this is how Lordship kindly then turns the page to page 70. The price is also mentioned. 2. Price. The ex-factory price declared to be or to be declared, the other charges as follows will be payable to you. Type A, rupees 5574.61 per 100 bags. 18% JCI raw jute linkage. Then there's a B is discount is 0, C is printing charges 50. And then GST rate. And Lordship kindly now sees inspection. Now Lordship kindly sees inspection. There's there's provision for inspection. Lordship kindly sees agency. The inspecting agency's name is given page 73, paragraph 12. Then paragraph 14, complaint redressal for substandard qualities. Yes, Lordship kindly, I missed out. Page 71. Page 71. 6. Each bale should be marked as under before tendering for pre-dispatch inspection to the inspecting agency. And 6L. Inspecting agency acceptance stencil at one place and an additional plastic seal on joints of bales, pack sheet and sticker on loops. So all these they inspected and then supplied. Now where are the notifications? Now, Lordship, now I come to the notifications issued under the JPM Act. Lordship kindly comes to from page 104. It should be from page 104. The notification 104 is Hindi. Lordship kindly come to 106. 106 onwards, we have been given these notifications published under section 4, under section 3. Lastly, it is page 132. Lordship, may I come to 132 straight away? These, and now Lordship kindly returns to paragraph 5 at page 133. The jute mills benefiting from the above arrangement are required to implement the relevant provisions of labor laws and regulations on the subject to the satisfaction of the state governments concerned and shall certify prompt payment to jute farmers and balers on production of raw jute. These are the conditions imposed. And Lordship, I should also point out that from day one, that is why it's never been implemented. Lordship kindly comes to the first of the lot, 106. Even since before. Page 106.
Yes.
Just see paragraph 2, just below the box. Procurement of jute bags for packing of food grains through the government e-marketplace GEM portal shall be initiated on trial basis. This is see, but this was never done. This trial basis, this never happened because or she will find this even thereafter at page 110, same paragraph 2. Then 114, paragraph 2. So this trial has never happened. And it goes on like this, Lordship, each and every one of them. Now, where is this? Where is the policy where they want to? Now, if you kindly come to page 271.
Second.
This is the one which has brought us to your lordships. Now, what happens is, kindly comes to page 271. Now, allocation policy. The Jute Textiles Ministry's allocation policy.
Yes.
Allocation policy, this is 2nd August. I am directed to refer to letter of even number dated 20th June, by which 6th revised supply plan for KMS 24-25 was issued. Based on the request received from Food Corporation of India, the 7th revised supply plan allocating packaging materials for KMS is sent herewith for necessary action. Now, what is troubling us here is paragraph 5. Paragraph 5. As per directions of DFPD state government of Chhattisgarh to procure 0.30 lakh bales and state government of Telangana to procure 0.20 lakh bales through GEM portal and state of Punjab to procure 0.20 lakh jute bales through reverse auction on GEM. Now, this is what is bringing us to my lord. Followed by, this is 2nd August. Now, Lordship kindly comes to 274. This was not implemented so far, no auction done. Now, once again, 274, 21st August. That was the 7th supply plan. but no e-auction done. Now comes 8th supply plan 274. Subject is 8th revised supply plan of food grain packaging. Now, bottom of the page, paragraph 5, as per directions of DFPD, state government of Chhattisgarh to procure 0.30 lakh jute bales and state government of Telangana to procure 0.20 lakh jute bales through GEM portal and the state government of Punjab to procure 0.20 lakh through reverse auction on GEM portal. Now, now, yes, but it needs to. This is our apprehension now, without undertaking a trial run, as is contemplated in the notices. That's September. Lordship, what I was humbly submitting, since Mr. Joint Mitra, I'm told, is on legs, I would like, because he would also like to argue, Lordship, may we continue tomorrow? Because tomorrow the origin side, there's urgency from our side, but then Mr. Mitra, because I shall be wrapping up 15 minutes, but Mr. Mitra will be there. So, Lordship, in case Lordship can give us some time tomorrow at 2 o'clock, then we can finish, and Mr. Raj.
The department they have served, I find it is in New Delhi. So they should have served it here SG office or Ministry of Oil. This is the first issue. The second petition I am happy. The original side matter I am happy. Within certainly AG was here in High Court itself. I did not the entire and we got the it's there in the.
So you have not served on the ministry?
Yes. It's served on the so far as original side matter is concerned, I am appearing for the commission. And the matter which is pending before the other bench, the repetition.
That is so for implementation.
Almost on the same issue. I shall point out before your lordship also. And
No, in this issue there is e-auction is under.
E-auction is the only issue. There is no e-auction there.
Why? To get the transparency of the entire jute industry, this e-auction was introduced, and that too only for 10% of the entire auction.
How one person can be introduced to violating the provisions of law?
No, it is not at all violating. I shall show your lordship. It is not at all violating the provision of law. The government introduced the e-auction within the periphery of the act. I shall show your lordship that also.
Served on 9th
Served
September.
on 9th September.
Service also 9th September. I am not appearing so far as that.
Very well.
Well, if I don't mind a long adjournment, but if they assure that they've been ordered that the presence is that they should introduce the e-auction just now. I don't mind any if they want some longer adjournment. It hasn't been from 2018. There's a
% of the entire auction.
How can you do it?
And that will not affect the right of the petitioner for the time being. Only 10%.
That's contrary to page 66. You see paragraph 4.
I shall file an affidavit and show your lordship. It is the entire e-auction procedure. It has been held from the act itself.
Okay, you want to file affidavit?
Yes, of course.
But lordship,
then the matter be the e-auction procedure will be stayed till then.
No.
I kindly do that. Otherwise, this will be contrary to para 4.
Then start the hearing the matter. Let the matter be concluded. Today or tomorrow, let the matter be concluded.
Lordship, I will make my submission. Let me. So, but my submission is this is contrary to the product. Yes, page 66. That subordinate legislation. It has to be under production control orders of the Jute Commissioner, so long as the statute remains.
That is the production control order.
Yes, and I've shown, and this is how the system has gone on for last from the time this act has come into force from 1987. Now, this government notifications from 18 says that they will try to go, they will go on a trial run to see this works. No trial run done. Trial. So whether it's possible to do it by the production control order of the Jute Commissioner, coupled with exercise of Jute Commissioner's powers under 7 and 8, without a trial run to see whether this is possible, how can they act contrary to altogether the giving a go by to this JTCO 2016 and saying go for a e-auction? They have to procure through the page 66, paragraph 4. Jute Commissioner textile take all the steps necessary for the implementation of the jute packaging materials act or any other, and may by order direct any jute mill to produce such quantities of such specifications of jute mills as may be specified in the order. For such implementation, the said order may be called the production control order. This is not a free market. This is no question of, after all, there's no question of transparency. You are fixing the price. You are placing the orders. There is no such thing as unfair pricing or this is the system, page 69, the PCOs. Specifying the price, this is how at page 70 and all the terms, this is how, and these PCSOs are issued. Lordship will find under statutorily, page 69, under the Jute Textile Control Order. If at all they have to try it, there has to be a trial run to see how this can be both within the statutory framework, if there is possible to go for a gem auction.
So tomorrow you want to argue?
I have finished Mr. Mitra. I would like him to join. Mr. Mitra.
Let's finish Mr. Mitra first. Thereafter you can start it. Okay. So come on tomorrow at 2 p.m.
Grateful.
And this matter will be the first matter.
Yes. Huh? কোনটা কোন ম্যাটারটা বলো? Which matter? Coal India. Okay. That was also pattern matter. এটা আগে করানো কি অর্ডার ওটা half an hour লাগবে, তাই তো? So I have a specially fixed matter at 2 p.m. tomorrow.
This matter after vacation.
Then in that case, I shall be asking for. Then let him give us reply.
No, I am ready to, because he has not been served with the copy.
No,
the read petition, I am not appearing.
Very well.
Not
It will take half an hour, the first matter. Thereafter I will take up the matter. Please take down.
And we will ask them to serve one more copy to the office of the.
Okay, you serve on.
Not to me, not to me.
Very well.
To the office.
To you.
No.
The office again.
I am not appearing. I cannot appear. You serve the additional office of the additional public.
Argument or behalf of the petitioner part in hard in part. Let the matter fixed tomorrow as a second matter at 2 p.m. Okay.
Grateful.
Call the list. ঠিক আছে ঠিক আছে Yes, Mr. Turana. Last day, I was raising a judgment of MMTC versus Vedanta, which is at page A 186, Milan. Compilations between A and B. A. Compilation. Spiral Karachi. 186. A and B. My judgments in judge. 822 दिए थे ना. Judge notice. Paragraph 11. Mrs. Vedanta Limited. Page 187, paragraph 14. 186 at the bottom is paragraph 11. Paragraph 11. Yes. As far as section 34 is concerned, the position is well settled by now that the court does not sit in appeal over the arbitral award and may interfere on merits on the limited ground provided under section 34(2)(b)(2). That is, if the award is against the public policy of India. As per the legal position clarified through decisions of this court prior to the amendments to Act 1996 in 2015, a violation of Indian public policy in turn includes a violation of the fundamental policy of Indian law, a violation of the interests of India, conflict with justice or morality, and the existence of patent illegality in the arbitral award. Additionally, the concept of the fundamental policy of Indian law would cover compliance with the statutes and judicial precedents, adopting a judicial approach, compliance with the principles of natural justice and Wednesbury reasonableness. Furthermore, patent illegality itself has been held to mean contravention of the substantive law of India, contravention of Act 1996, and contravention of the terms of the contract. It is only if one of these conditions is met that the court may interfere with the arbitral award in terms of section 34. It has been made very, very clear, Milan. But such interference does not entail a review of the merits of the dispute and is limited to situations where the findings of the arbitrator are arbitrary, capricious, or perverse, or when the conscience of the court is shocked, or when the illegality is not trivial but goes to the root of the matter. The patent integrity has to go to the root of the matter, Mila. An arbitral award may not be interfered with. Its view taken by the arbitrator is a possible view. An arbitral award may not be interfered with if the view taken by the arbitrator is possible view based on facts. Yes. So it has been made very clear when section 34 court can look into and interfere into the merits of the award. Lastly, I was also referring to a judgment of BCCL versus Ahuja Mila, which was not there with me. I have brought a copy that of. mailed it.
I'm referring to page 3 of this judgment, my lord. The third paragraph, my lord, from the top.
Yes.
There are limitations upon the scope of interference in awards passed by the arbitrator. When the arbitrator has applied his mind to the pleadings, the evidence adduced before him, and the terms of the contract, there is no scope for the court to reappraise the matter as if this were under an appeal. And even if two views are possible, the view taken by the arbitrator would prevail. So long as an award made by an arbitrator can be said to be won off by a reasonable person, no interference is called for. However, in cases where an arbitrator exceeds the terms of the agreement or passes an award in the absence of any evidence which is apparent on the face of the award, the same could be set aside. So my humble submission, my lord, when the arbitrator has passed an award for payment of license fee for lock-in period, he has considered the terms of the contract, he has considered the evidence, he has considered all the documents before him. Such an award is neither against fundamental policy of India. It cannot be called a patent illegality.
Yes.
It is not against justice. It is not against morality. This absolutely was passed in terms of the contract according to the provisions of. आप देखना चाहते हैं तो देख लीजिए, मेरे को दे दीजिए. And then another judgment I would refer, my lord, which is at page A234. A234. हाँ, आपको तो है, तो सारा है. मैंने तो आपको दिया था. हाँ, yeah. I'm referring to paragraph 18, my lord, at page 234. 234. Okay. I'm sorry, it is 13, my lord. The fifth line.
No, you have just referred earlier page
234, my lord. A234.
Previous to that. A
186, my lord.
186.
Yes, ma'am. A 186. MMTC.
Okay.
This is at A234 is Tamil Nadu Civil Supplies versus Albert and Company, my lord. Paragraph 13, my lord. The fifth line of the paragraph, my lord.
Yes.
The court can interfere in the decision only if the conscience of the court in any sense touched by palpable injustice. The arbitrator is a judge of the choice of the parties, and his decision, unless there is an error apparent on the face of the award, which makes it unsustainable, it is not to be set aside, even if the court as a court of law would come to a different conclusion on the same facts. The court cannot reappraise the evidence and it is not open to the court to sit on appeal over the conclusion of the arbitrator. So what I wanted to submit here, my lord, this judgment says that section 34 court is not an appeal.
Not a court of appeal.
When the arbitrator has taken a view, a possible view, it should be accepted, it should be considered. The next is, my lord, A191. It is Navodaya Mass Entertainment Limited versus JM Combines.
Yes.
I refer to the third paragraph of the page, my lord.
Yes.
In our opinion, the scope of interference of the court is very limited. Court would not be justified in reappraising the material on record and substituting its own view in place of the arbitrator's view. Where there is an error apparent on the face of the record, or the arbitrator has not followed the statutory legal position, then only it would be justified in interfering with the award published by the arbitrator. Once the arbitrator has applied his mind to the matter before him, the court cannot reappraise the matter as if it were an appeal, and even if two views are possible, the view taken by arbitrator would prevail. And there is another judgment of Delhi High Court, my lord, SMS Water Grace BMW Private Limited versus Government of NCT. I would refer para 55 to 60 here, my lord. (55 to 60) I will be referring with. May I place it, my lord?
Yes.
55. Having stated the above, it is also necessary to mention that the view of this court with regard to the petitioner's case is not relevant, as the scope of examination in these proceedings is limited to ascertaining whether the impugned award is vitiated by patent illegality or that the impugned award is in conflict with the public policy of India. Clearly, none of the two grounds are met. It is well settled that an arbitral tribunal is also the final authority for interpreting the contract, and the impugned award cannot be interfered with merely because a different interpretation is possible. In this judgment, my lord, the Honorable Court has also referred to a judgment in McDermott International, which is again a very famous judgment, my lord, for section 34 court. It is tried that the terms of the contract can be express or implied. The conduct of the parties would also be a relevant factor in the matter of construction of a contract. The construction of the contract agreement is within the jurisdiction of the arbitrator, having regard to the wide nature, scope, and ambit of the arbitration agreement, and they cannot be said to have misdirected themselves in passing the award by taking into consideration the conduct of the parties. It is also tried that correspondence exchanged by the parties are required to be taken into consideration for the purpose of construction of a contract. Interpretation of a contract is a matter for the arbitration to determine, even if it gives rise to determination of a question of law. Now, my lord, they have submitted before the tribunal that I have been informing Mr. Surana of breaches continuous, even though there is no record on the arbitral tribunal. Then one fine morning, they terminate the contract on 31st of October 2011, stating the termination is forthwith, without following the conditions of the agreement, that is condition 31 of the agreement, which requires them to serve me a 30 days notice. The arbitrator has come to held that since they have not complied with the terms as stated in clause 31 of the agreement, the claimant is entitled for license fee for the lock-in period. 58, my lord.
Yes.
May I also place this the balance portion of this 55 also, my lord? Once that is held, that the arbitrator held at the jurisdiction, no further question shall be raised, and the court will not exercise its jurisdiction unless it is found that there exists any bar on the face of the award. 57. An associate builder versus Delhi Development Authority has stated in paragraph 42.3. See, equally the third subhead of patent illegality is really a contravention of section 28.3 of the Arbitration Act, which reads as under. Rules applicable to substance of dispute. In all cases, the arbitral tribunal shall decide in accordance with the terms of the contract and shall take into account the uses of the trade applicable to the transaction. This last contravention must be understood with caveat. An arbitral tribunal must decide in accordance with the terms of the contract, but if the arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of contract is primarily for the arbitrator to decide, unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do so. Now, there is nothing like this in the award, my lord. 58, my lord. This is again a decision in Sumitomo Heavy Industries decided by Honorable Supreme Court, my lord. The umpires has considered the fact situation and placed a construction of the clauses of the agreement, which according to him was the correct one. One may at the highest say that one would have preferred another construction of clause 17.3, but that cannot make the award in any way perverse. Nor can one substitute one's own view in such a situation in place of the one taken by the umpire, which would amount to sitting in appeal, as held by this court in Quality Manufacturing Corporation. The court, while considering challenge to arbitral award, does not sit in appeal over the finding and decision of the arbitrator, which is what the High Court has practically done in this matter. The umpire is legitimately entitled to take the view which he holds to be correct one after considering the material before him and after interpreting the provisions of the agreement. If he does so, the decision of the umpire has to be accepted as final and binding. 59. This is again a decision of the Supreme Court, my lord, delivered in Rashtriya Ispat Nigam Limited versus Diwan Chand Ramsaran. In any case, assuming that clause 9.3 was capable of two interpretations, the view taken by the arbitrator was clearly a possible, if not a plausible one. It is not possible to say that the arbitrator had traveled outside his jurisdiction or that the view taken by him was against the terms of the contract. That being the position, the High Court had no reason to interfere with the award and substitute its views in place of the interpretation accepted by the arbitrator. The legal position is that in this behalf has been summarized in para 18 of the judgment of this court in Sale versus Gupta, which also I have placed before your lordship, and similar views have been taken in Sumitomo Heavy Industries, which also I have placed before your lordship.
Yes.
Then paragraph 60, my lord, in MSK projects.
Yes.
If the arbitrator commits an error of the construction of the contract, that is an error within his jurisdiction. But if he wanders outside the contract and deals with matters not allotted to him, he commits a jurisdictional error. If he decides anything contrary to the agreement,
that is outside the jurisdiction.
That's jurisdictional error. Extrinsic evidence is admissible in such cases because the dispute is not something which arises under or in relation to the contract or dependent on the construction of the contract or to be determined within the award. The ambiguity of the award can, in such cases, be resolved by admitting extrinsic evidence. The rationale of this rule is that the nature of the dispute is something which has to be determined outside and independent of what appears in the award. Such a jurisdictional error needs to be proved by evidence extrinsic to the award. Now, whatever the arbitrator has decided in terms of making payment for the period, 5 years period, lock-in period, is based on the contract itself. May I place another judgment delivered by Honorable Supreme Court in Satlas Construction versus Union Territory of Chandigarh. Paragraph 10 to 13, my lord. मेल किया मेल किया इसके पहले वाले में इसके पहले तो भेजा है उसमें इसके पहले भेजा नहीं तो मैं आपको दे दूंगा इसके पहले वाली मेरी मेल है उसमें देख लीजिएगा साइटेशन बोलिए साइटेशन इज Satlas Construction versus Union Territory of Chandigarh. आप लिख लीजिए ये 3 जजमेंट भेजे थे मैंने आपको एकदम. Paragraph 10, my lord. May I please?
Paragraph 10.
Yes, my lord. We are not in agreement with the approach adopted by the learned single judge. The dispute in question had resulted in a reasoned award. It is not as if the arbitrator has not appreciated the evidence. The arbitrator has taken a plausible view, and in our view, as per us, the correct view, that the very nature of the job to be performed would imply that there has to be an area for unloading, and that too in the vicinity of 5 kilometers. It was a contract that unloading area has to be within the place which has been given for development, my lord. Paragraph 11, my lord. It has been opined by this court that when it comes to setting aside of an award under the public policy ground, it would mean that the award should shock the conscience of the court and would not include what the court thinks is unjust on the facts of the case, seeking to substitute its views for that of the arbitrator to do what it considers to be justice, which is what has been stated in Associated Builders. The approach adopted by the learned additional district judge, Chandigarh, was thus correct in not getting into the act of reappreciating the evidence as the first appellate court from a trial court degree. An arbitrator is a chosen judge by the parties, and it is on limited parameters can the award be interfered with. It has also been stated in Sudarshan Trading, which I have placed earlier, my lord. May I also refer a latest judgment delivered by this Honorable Court, my lord, on 13th of August 2024 in Damodar Valley Corporation versus BLA Projects. AP Com number 231 of 2020. And refer to paragraph 63 and 64, my lord. On page 8, my lord. Last page, my lord.
Yes.
Paragraph 63 and 64, my lord. This court, as is well settled by the Supreme Court in several judgments cited by the parties, including Associated Builders, Sanjeong Engineering, Patel Engineering, UHL Power, cannot enter into reappreciation of evidence like a regular first appellate court. Sitting in a challenge under Section 34 of the 1996 Act. The limited window which could have been invoked by the DVC is found in subsection 2A of Section 34, which makes patent illegality a ground for challenge. However, such patent illegality has to appear on the face of the award. Also, the proviso to the subsection stipulates that an award shall not be set aside on the set score merely on the ground of an erroneous application of law or by reappreciation of the evidence.
Yes.
64. In the present case, I do not even find any erroneous application of law, let alone any equation to reappreciate the evidence. The judgment of the arbitrator is perfectly well reasoned and supported by cogent evidence, and as such, none of the grounds of challenge under Section 34 of the 1996 Act are established. Another judgment has been delivered by this Honorable Court, my lord, recently on 5th of August 2024, which is in Union of India versus Senbo Engineering Limited. May I refer paragraph 32 and 33, my lord.
Yes.
The Supreme Court in Satluj Construction Limited, which I have recently just now placed before me, lord, has amply laid down the contours of interference under Section 34 of the 1996 Act. In such a challenge, there cannot be any interference when the award is reasonable and on the basis of a plausible view. Reappreciation of evidence cannot normally be done, and when it comes to setting aside of an award under the public policy, the award should shock the conscience of the court. Merely because the court thinks it unjust on the facts of the case, it cannot substitute its views for that of the arbitrator to do what it considers to be justice. In H.L. Batra Supra, the Supreme Court also laid down the scope of arbitration, where an award is set aside and a new arbitrator is appointed for setting aside of disputes. In such circumstances, it was held that the second arbitrator's scope was not confined only to the claims which have been originally filed before the first arbitrator. May not be relevant to our case. May I place another judgment of Supreme Court, my lord, delivered in KB Muhammad Jakir versus Regional Sports Center. Paragraph 6, my lord. on the page, on page 2, my lord.
Yes.
We have had counsel with the parties and we have perused the award. The award runs into considerable detail as it is a speaking award. While dealing with this part of the claim, the arbitrator in paragraph so and so of the award has given detailed regions. As far as my award is concerned, delivered by the learned arbitrator, he has given quotient regions, which meets the requirements of section 31 of Act 1996. We are of the view that the settled position of law is that the court should not substitute its own view for the view taken by the arbitrator while dealing with the proceedings for setting aside an award. It is equally well settled where the arbitrator acts within the jurisdiction, the reasonableness of the reasons given by the arbitrator is not open to scrutiny by courts. However, if the reasons given by the arbitrator is not open to However, if the reasons are such as no person of ordinary prudence can ever approve of them, or if the reasons are so outrageous in their defiance of logic that can shock the conscience of the court, then it is a different situation. And in an appropriate case, the court may interfere. However, the degree of such unreasonableness must be greater than the standard in a certiorari proceedings. We find that the arbitrator in this case has reached a finding of fact on the materials on the record about the delay on the part of the respondent, as it has also been held by the arbitrator that because of such a delay, the claimant was put in great difficulty in completing the work in time. It is nobody's case that by doing so, the arbitrator has acted beyond his jurisdiction or committed any legal misconduct. I also refer another judgment of the Honorable Supreme Court, my lord, delivered in UHL power.
Yes.
I'll be referring, my lord, paragraph 14, 15, 14 to 23, 20, 21, my lord, 14 to 21.
Okay.
May I please, ma'am?
Yes.
Paragraph 14, my lord. This court also accepts as correct the view expressed by the appellate court that the learned single judge committed a gross error in reappreciating the findings returned by the arbitral tribunal and taking an entirely different view in respect of the interpretation of the relevant clauses of the implementation agreement governing the parties, in as much as it was not open to the said court to do so in proceedings under section 34 of the Arbitration Act by virtually acting as a court of appeal. Paragraph 15. Paragraph 15 deals with the MMTC versus Vedanta,
Vedanta,
which I have already placed.
Yes.
I'll come to paragraph 16, my lord. A similar view as stated above has been taken by this court in K. Sukumar versus Hindustan Petroleum Corporation. The contents of the power of the court under section 34 of the Act are too well established to require any reiteration. Even a bare reading of section 34 of the Act indicates the highly constricted power of the civil court to interfere with the arbitral award. The reason for this is obvious. When parties have chosen to avail an alternative mechanism for dispute resolution, they must be left to reconcile themselves to the wisdom of the decision of the arbitrator, and the role of the court should be restricted to the bare minimum. Interference will be justified only in cases of commission of misconduct by the arbitrator, which can find manifestation in different forms, including exercise of legal purpose by the arbitrator. Section 5 of the Act also clearly says minimum interference by the court. Then, my lord, I will raise before your lordship a judgment of Dyna Technology Private Limited, which is at page 41 of this compilation, my lord. Page A41, and the relevant paragraph is 26 and 27, which are at page A46, my lord.
Dyna Technology.
Dyna Technology.
Yes.
Paragraph 26 and 27 is A46, my lord. May I place it, my lord? There is no dispute that Section 34 of the Arbitration Act limits a challenge to an award only on the grounds provided therein or as interpreted by various courts. We need to be cognizant of the fact that arbitral awards should not be interfered within a casual and cavalier manner, unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative approach and cannot be equated with the normal appellate jurisdiction. It's very, very clear, my lord. The mandate under Section 34 is to respect the finality of the arbitral award and the party autonomy to get their dispute adjudicated by an alternative forum as provided under the law. If the courts were to interfere with the arbitral award in the usual course on factual aspects, then the commercial wisdom behind opting for alternate dispute resolution would stand frustrated. 27, my lord. Moreover, umpteen number of judgments of this court have categorically held that the courts should not interfere with an award merely because an alternative view of the facts and interpretation of contract exists. The court need to be cautious and should defer to the view taken by the arbitral tribunal, even if the reasoning provided in the award is implied, unless such award portrays perversity unpardonable under Section 34 of the Arbitration Act. A minimum interference by the Honorable Court as far as Section 34 applications are concerned. Paragraph 18, my lord. In Parsa Kante Collieries Limited, this UHL Power, my lord.
Yes.
I'm coming to page 6, my lord, referring page 6.
Yes.
Paragraph 18, my lord. In Parsa Kante Collieries, which has been dealt in McDermott also, which has been dealt in Rusty Ispat, and which has been dealt in Associated also, my lord. 9.1, my lord. It is further observed and held that construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. It is further observed by this court in the aforesaid decision in paragraph 33 that when a court is applying the public policy test to an arbitration award, it does not sit as it does not act as a court of appeal, and consequently errors of fact cannot be corrected. A possible view by the arbitrator on facts has necessarily to pass muster, as the arbitrator is the ultimate master of the quality and quantity of the evidence to be relied upon when he delivers his arbitral award. This I have also stated in Associated Builders, paragraph 31. Paragraph 20, Southeast Asia.
Yes.
Marine Engineering Construction Company versus Oil India Limited, 2025 SCC 164. It is a settled position that a court can set aside the award only on the grounds as provided in Arbitration Act as interpreted by the courts. Recently, this court in Dyna Technologies laid down the scope of such interference. This court observed as follows. The reference of Dyna
Technologies.
Next, 13 Miller. It is also settled law that where two views are possible, the court cannot interfere in the plausible view taken by the arbitrator supported by reasoning.
Yes.
I mean, whatever awards have been passed in my favor, every possible reason has been given by the learned arbitrator. That fully meets the requirement of Act 1996, Section 31. A detailed reasoning has been given. This
Yes.
court in Dyna Technologies, again the same thing, my lord. 21. In the instant case, we are of the view that interpretation of the relevant clauses of the implementation agreement as arrived at by the learned sole arbitrator are both possible and plausible. Merely because another view could have been taken can hardly be a ground for the learned single judge to have interfered with the learned with the arbitral award. In the given facts and circumstances of the case, the appellate court has rightly held that the learned single judge exceeded his jurisdiction in interfering with the award by questioning the interpretation given by the relevant clauses of the implementation agreement, as the reasons given are backed by logic. We therefore uphold the decision of the appellate court that has restored the findings returned in the arbitral award dated so and so to the effect that the state of Himachal Pradesh had proceeded to terminate the implementation agreement before expiry of the prescribed period, which could have been extended to 24 months. May I place another small judgment of the Honorable Supreme Court delivered in Haryana Tourism Mela. Haryana Tourism Limited versus Kandhari Beverage Limited.
Yes.
I would like to refer to paragraph 7, 8, and 9, my lord. At page 3, my lord. May I please, my lord?
Yes.
So far as the impugned judgment and order passed by the High Court quashing and setting aside the award and the order passed by the additional district judge under section 34 of the Arbitration Act are concerned, it is required to be noted that in an appeal under section 37 of the Arbitration Act, the High Court has entered into the merits of the claim, which is not permissible in exercise of powers under section 37 of the Arbitration Act. As per settled position of law laid down by this court in a catena of decisions, an award can be set aside only if the award is against the public policy of India. The award can be set aside under section 34 or 37 of the Arbitration Act if the award is found to be contrary to fundamental policy of Indian law, interest of India, justice or morality, if it is patently illegal.
Yes.
These are the areas where a court can interfere. None of the aforesaid exceptions shall be applicable to the facts of the case on hand. And my case also. The High Court has entered into the merits of the claim and has decided the appeal under section 37 of the Arbitration Act, as if the High Court was deciding the appeal under the judgment and decree passed by the learned trial court. Thus, the High Court has exercised the jurisdiction not vested in it under section 37 of the Arbitration Act The impugned judgment and order passed by the High Court is hence not sustainable. But if I do section 34, I have a right to appeal under section 37. The scope of 37 is even narrower than section 34 code.
Yes.
Section 34 code section 37 code can only look into the judgment of 34, whereas 34 can look into various other
Arbitral award. Yes.
In view of the above, and for the reasons stated above, the present appeal succeeds. The impugned judgment and the order passed by the High Court is hereby quashed and set aside. The award passed by the arbitrator and the order passed by the additional district judge under section 34 Act overruling the objections are hereby restored. There is another judgment passed by the Honorable Supreme Court in National Highway Authority of India versus ITD Cementation. 2015-14 SCC 21. I will be referring to paragraph 16 to 20, my lord. Page 8.
Yes.
Paragraph 16, my lord. 112. This is again the McDermott, my lord, which I have already placed. May I place it a small item, you know? It is tried that the terms of the contract can be expressed or implied. The conduct of the parties would also be a relevant factor in the matter of construction of a contract. The construction of the contract agreement is within the jurisdiction of the arbitrators, having regard to the wide nature, scope, and ambit of the arbitration agreement, and they cannot be said to have misdirected themselves in passing the award by taking into consideration the conduct of the parties. It is also tried that correspondences exchanged by parties are required to be taken into consideration for the purpose of construction of a contract. Interpretation of a contract is a matter for the arbitrator to determine, even if it gives rise to determination of a question of law. 17. This Rusty Ispat I have already placed. Sumitomo Heavy
Industries. You have already placed.
Then, my lord, page 9, 28 rules applicable to substance of dispute. In all cases, the arbitral tribunal shall decide in accordance with the terms of the contract and shall take into account the usages of the trade applicable to the transaction. This last contravention must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract, but if the arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of a contract is primarily for an arbitrator to decide unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do.
Yes.
It is thus well settled that the construction of the terms of the contract is primarily for an arbitrator to decide. He is entitled to take the view which he holds to be correct one after considering the material before him and after interpreting the provisions of the contract. The court, while considering challenge of an arbitral award, does not sit in appeal over the findings of the decisions unless the arbitrator construes the contract in such a way that no fair-minded or reasonable person could do. In McDermott, my lord, they have also stated it is also tried that the correspondence exchange. Now here the correspondence has been exchanged. So this is as far as the judgments are concerned, my lord, which gives a pretty good amount of light how and when an award can be set aside and what are the circumstances.
Yes.
I have just to recapitulate, my lord, I have cited Associated Builders, I have cited Haryana Tourism, I have cited Dyna Technologies.
Sumitomo.
Yeah, I'm coming to that, my lord.
Yes.
I have cited this Southeast Asia.
Yes.
I have also cited McDermott, my lord. I have cited Sumitomo. I have cited Quality Manufacturing Corporation, the earlier day, my lord.
Yes.
That was at page A164, Quality. I have also cited Rashtriya Ispat Nigam versus Diwan Chand as page 230. I have also cited MSK projects as at page 215. I have also, I have not cited the Hindustan Petroleum A266. A266, my lord. Wait. My lord, this is
Hindustan
the judgment
Petroleum Corporation Limited.
My lord,
Hindustan Petroleum
my lord,
Corporation.
this is the judgment delivered in Hindustan Petroleum Corporation Limited by Banu Construction at Madras High Court by Justice Sanjeev Banerjee when he was the Chief Justice over
Yes.
there.
Page 265.
Page 266, my lord.
Page 266. Yes.
The court has to yield, the first line, my lord. The court has to yield to the arbitrator's assessment as to the quality and quantity of the evidence. The arbitrator's interpretation of the agreement between the parties, unless such interpretation is patently unreasonable or absurd to the meanest mind or is opposed to the public policy. Even errors of law committed by the arbitrators are not amenable to correction unless such errors lead to manifest miscarriage of justice. May I refer another judgment of my lord delivered by Honorable Supreme Court in Oriental Insurance Company Limited versus Diamond Products Limited at page A320. A2320.
Yes.
Paragraph 16.1, my lord. The seventh line in the paragraph 16.1, my lord. The bottom, my lord.
Yes.
The court cannot set aside the award by reappreciating the evidence which is taken into consideration by an arbitral tribunal. The court cannot set aside the award by reappreciating the evidence which is taken into consideration by an arbitral tribunal. You know, this PR Shah also I have placed on the last occasion. MMTC I have placed. Tamil Nadu Civil Supplies I have placed. Navodaya I have placed, my lord. Another judgment is, my lord, Maharashtra State Electricity Distribution Company Limited versus Datar Switchgear. P185, my lord. P 185 million.
Maharashtra State Electricity.
Maharashtra State Electricity Distribution Company Limited versus Datar Switchgear Limited.
Yes.
Again, a Supreme Court judgment.
Paragraph 43.
43 million. Just 2-3 lines I'll be. At the bottom, my lord.
Yes, read out.
Bottom 4 lines, my lord. The proposition of law that the arbitral tribunal is the master of evidence and the finding of fact which are arrived at by the arbitrators on the basis of evidence on record are not to be scrutinized as if the court was sitting in appeal, now stands settled by catena of judgments pronounced by this court without any exception thereto.
Yes.
Another judgment, my lord, at A 368. The Indian Oil Corporation versus Sri Ganesh Petroleum 2022 Live Law SC 121.
A?
Page 368, my lord.
368.
I'll be referring to paragraph 45 and 46, my lord.
Yes.
At page 13, my lord. However, a distinction has to be drawn between failure to act in terms of contract and an erroneous interpretation of the terms of the contract. An arbitral tribunal is entitled to interpret the terms of the terms and conditions of a contract while adjudicating a dispute. An error in interpretation of a contract in a case where there is valid and lawful submission of arbitral disputes to the arbitral tribunal is an error within his jurisdiction only.
Yes.
46. The court does not sit in appeal over the award made by the arbitral tribunal. The court does not ordinarily interfere with the interpretation made by the arbitral tribunal of a contractual provision unless such interpretation is patently unreasonable or perverse. Now here, my lord, the learned arbitrator has considered the terms of the contract very minutely and has considered the correspondence also. Where a contractual provision is ambiguous or is capable of being interpreted in more ways than one, the court cannot interfere with the arbitral award only because the court is of the opinion that another possible interpretation would have been a better one. Whatever arbitrator has considered, unless it is really something which is totally malified, I would say, contrary to the agreement, contrary to the law, contrary to the fundamental principles, it cannot be set aside.
Yes.
UHL Power, my lord, I have already. Yes. MMTC, I have placed before your lordship. K. Sugumar also I have placed. Paras Conta, I have also placed. This National Highway ITT cementation, I have also placed, my lord. McDermott also I have placed. DVC, BLA, DVC also this, our court has passed. That also I have placed. KB Muhammad Jakir also I have placed, my lord. So these are the judgments in regard to payment of license fee by the arbitrator is concerned. I have placed. Now, as far as another big issue is the award made to me by the arbitrator, by the learned arbitrator for payment of additional rent. On a award bear for the petition volume 2 of 698. Yes. 157.
Yes.
But here the only objection which they have taken before your lordship is that there was no amendment in terms of the agreement under paragraph 40, under clause 43 of the act. Now this stand was never taken before the arbitral tribunal. My humble submission that they can only argue on those factors or those matters or plead on those things which have been taken before the tribunal. Now, this award has been made on the basis of a supplementary agreement in which they have agreed to perform their obligations and cover with a separate letter, which they never did. So, I have established my claim with certain amount of correspondence which were exchanged between the parties. And the arbitrator has come to the conclusion that my claim is fair, reasonable, uncontrovertible, and such materials were never contradicted. There was no cross-examination also.
Yes.
Now, these paragraphs were placed before your lordship on the earlier occasion. If your lordship permit me, I can again place them.
Paragraph 71.
Paragraph 73 to 76.
Yes.
Can I place it again?
No, not necessary. You have already placed it.
I'll just place my lord 75 and 76.
Okay. Okay.
As a matter of fact, Mr. Surana gave me a sheet of paper containing his revised claim at rupees 97,66,000 on account of security deposit and rupees 7.71 crores on account of license fee. I am, however, not inclined to uphold such claim, which takes into account as calculations which shows many imponderables. To be fair on the respondents, I must admit the respondents did not have sufficient opportunity or time to deal with the same matter. What I wanted to submit, because this is absolutely contrary to the discussions which have taken place. The evidence which was recorded in the arbitral minutes, absolutely contrary. I will place before your lordship certain judgments of the Supreme Court, which says that these statements can be, the claim can be amended at any point before the delivery of judgment. And I have revised my claim based on certain documents which were in their possession, which they never parted with me, which they were supposed to part with me. These documents were disclosed only during the arbitral proceedings. Had they not disclosed, I would not have been able to know. So I just wanted to revise
Your additional license fee and security deposit. This was your claim before the learned arbitrator, but learned arbitrator had choose not to give you the same. So you have filed separate 34 application for that. So we have to deal with that matter on that 34 application. Okay, not the 34 filed by them. Okay, these are the separate. They have to give him the opportunity to contradict.
No, Milord, they have objected to that. That's why I am dealing.
No, that may be, but I shall not deal with this matter in this 34 application. You understand? As you have filed a separate 34 application regarding these matters, I will hear this matter on that point, on that APO, I think. What is the number?
I was only dealing why because they have made submissions against those awards which have been awarded to me. One was license fee, where they say that Mr. Surana has not established that he has suffered damages.
Yes.
I have made my necessary.
So you have awarded 50 lakh restricted to
50 lakhs on account of interest on security deposit
and
and 3.95 crores on account of.
they have challenged this.
They have challenged.
They have challenged this in this 34 application. So you would be restricted on that point.
I'm restricting myself.
Okay. So your claim was 97 lakh 66,000 in respect of the additional license fee.
My claim before the tribunal for additional license fee and security deposit was 50 lakhs on account of interest on security deposit.
Yes.
I was not aware how much security deposit they have received.
I understand.
And I have just roughly calculated the additional amount of license fee to an extent of 3.95 crores, which I have claimed as with the guardian arbitrator has considered, allowed me based on evidence, based on records, based on correspondence.
Yes.
The challenge by the petitioner in respect of the above claim, this claim, is in paragraph 40 AAA FFF at page 80 to 91 of their petition, my lord. Volume 1. 698, volume 1, petition. 6.
Yes.
The learned arbitrator has passed the award and gave his findings based on supplementary agreement dated 14th of June 2008 and several other relevant documents and evidence on record. The respondent number 1 relies and reiterates what has been stated in paragraph 19 of his affidavit. I have dealt this in my AO in paragraph 19. The Honorable Court, while considering challenge to the arbitral award, does not sit in appeal over the findings and decision of the arbitrator. This finding being a finding of fact arrived at by the learned arbitrator after considering various documents, testimonies of witness, submissions made by both the parties and evidence on record is not open to interference by the Honorable Court for re-examination or re-examining or re-evaluating the evidence or drawing interference from the material placed before the learned arbitrator.
Yes.
What I wanted to say, Milord, that this has been passed on the basis of various documents before the arbitral tribunal, testimonies of witness, submissions made by both the parties, and evidence on record, and these are all not open to interference by the Honorable. The learned arbitrator has extensively gone into the evidence and evaluated the entire evidence before him and has published a detailed speaking award giving cogent, meaningful, and lawful reasons.
Yes.
It is submitted that the law is settled that where the arbitrator has assessed the material and evidence raised before him in detail, the Honorable Court, while considering the objections under Section 34 of the said Act, does not sit as a court of appeal and is not expected to reappreciate and or re-evaluate the evidence and assess the case and reassess the case of the parties. The jurisdiction under Section 34 is not appellate in nature, and an award passed by the arbitrator should not be set aside on the ground that it was erroneous. It is not open to the Honorable Court to interfere with the award merely because, in the opinion of the Honorable Court, another view is possible. It is most respectfully submitted that the scope and jurisdiction of the Honorable Court in these circumstances is to see whether the view taken by the arbitrator is plausible on the facts, pleadings, documents, and evidence before the learned arbitrator. Even if on the assessment of the material, the Honorable Court, while considering the objections under Section 34, is of the view that there are two views possible, and arbitral tribunal has taken one of the possible views, which could have been taken on the materials before it, the Honorable Court ought to be reluctant to interfere. It is most respectfully submitted that the Honorable Court is not to substitute its view with the view of the learned arbitrator if the view taken by the arbitrator is reasonable and plausible. It is also settled law that where two views are possible, the court would not interfere in the plausible view taken by the learned arbitrator, supported by reasoning. I have placed various judgments in support of my submission. One of them is Dyna Technologies, Southeast India I have submitted, McDermott I have submitted, Miller, Sumimoto I have submitted, Quality I have submitted, Rusty Nigam I have submitted, MSK I have submitted, Oriental Insurance I have submitted, Hindustan Petroleum also I have submitted, Miller. The evaluation of evidence by the arbitral tribunal may be erroneous, and perhaps the Honorable Court may take a different view, but that is not the scope of the examination under Section 34.
Yes.
Of the Act. And this Honorable Court should not interfere with the arbitral award merely on the ground that it does not concur with the inference drawn by the arbitral tribunal from the documents and evidence led by the parties. The arbitral award is not contrary to the fundamental policy of India or opposed to the justice or morality as wrongly alleged. I have submitted my this associated builders also I have relied upon. Sanjeong also I have relied upon. Sanjeong, they say in Sanjeong engineering, Milord, the Honorable Supreme Court has stated. Secondly, it is also made clear that reappreciation of evidence, which is what an appellate court is permitted to do, cannot be permitted under a ground of patent illegality appearing on the face of the award. It is submitted that the award made by the arbitrator may be wrong either on law or on fact, and error of law on the fact on the face of it could not nullify the award. The award is a speaking one, Milord. The learned arbitrator is assigned of sufficient, meaningful, and cogent reasons in support thereof. Interpretation of a contract, it is tried, is a matter for the arbitral tribunal to decide, to determine. The respondents have committed a clinical conspiracy where there would not be direct evidence. It can only be inferred from circumstantial evidence for which one has to investigate and gather evidence. Despite repeated requests and reminders, the respondents did not make over copies of the supplies by them. When I have executed the supplementary agreement on 14th of June 2008, it was very clearly that whenever you execute, you must bring it to my knowledge first. Tell me who is the party. Because, my lord, it's a relation between a tenant and landlord. A landlord must know who is coming. What is his background? That is because that condition was stated. A landlord cannot accept Tom, Dick, Harry. It has to be a reasonable one, good tenant, so that there is peace of mind all the time. A coordinate bench of this Honorable Court has clearly held in Mitesh Mehta versus Saregama that it is settled law that interpretation of the terms of the contract is within the domain of the arbitrator. It is there in B126 million. Should I place it? No, not necessary. The learned arbitrator has passed an award for a sum of rupees 4 crore 45 lakh to me. 50 lakh on account of interest on security deposit and 3.95 crores on account of additional license fee as originally claimed. Now, this claim when I made, it was absolutely guesswork.
The arbitrator has only awarded this.
And why I am entitled for that higher sum, I will come to that. The claims of the claim of the claimant did not include the quantum of security deposit made or deposited by the sub-licenses created by the petitioner. I have got only 50 lakh on account of interest on security deposit. I did not claim the security deposit. I was not aware how much they have collected. However, the award based on copies of 4 sub-license agreements which are on record were executed by the Pantaloon Retail at page 637 of volume 5. Now, like this, my lord, there are 4 agreements on arbitral record, and all 4 are before your lordship.
Yes. Or all placed before the tribunal.
All placed before the tribunal. And upon seeing these documents, I have revised my statement of claim, which should have been accepted by the learned tribunal, which was not accepted because of the only reason that it will prolong the arbitration. And when I submitted my revised claim, my lord, the arbitration continued for more than 15 months thereafter. It is not that from the next month or the next week the award was published. Page 637, you know, kindly come to clause 5.
Yes. Shop room number 6.
Clause number 5, my lord. Page 637.
637.
Yes. It is a sub-license agreement executed by Pantaloon G.A. Freedom Fashions
Limited.
Clause number 5, my lord. Shop number 6, having chargeable area of 850 square feet, being carpet area of 467 square feet. So this is the area, my lord. Significant here is 467 is the carpet area.
Chargeable area is 850.
That is 82% more. Whereas in my agreement, I was claiming only 10%.
10% of the carpet area.
Carpet. Now kindly come to clause 10. This shows what is the compensation, that is what is the licensing.
Yes.
The compensation for the premises shall be rupees 45 per square feet of chargeable area amounting to rupees 74. I have executed an agreement with Pantaloon at rupees 19.50. And they have executed this agreement at 45. As per my understanding with them, the difference between 45 and 1950 should have come to me on day 1, whenever they received the license fee. Neither they gave me that additional license fee, nor they gave me the security deposit, nor they gave me the copy of the agreement. They kept me blind. Kindly come to clause 11 on page 639 below. Clause D below.
Yes.
The compensation reserved herein shall escalate 15% after the end of every 3 years over the existing compensation. Today, if the rate is 100 rupees, after 3 years it will be 150. Again, after 3 years, it will be 15% higher of 150, the last paid. And then the security deposit below, paragraph clause 11 below. An interest-free security deposit equivalent to 6 months compensation amounting to rupees so and so shall be payable by the intended licensee to the licensor as security for the observance and performance of its obligation. But security deposit has been received by them before they have parted with the possession of the showroom to the party. As per my understanding, I should have got the security deposit from day one when they received. They did not part with it. So I have placed before your lordship 3 clauses in the area which is clause 5. Another is clause 10, which is for the license fee and the escalation also. And the third is security deposit.
Security.
So I was concerned about the amount of security deposit and additional license fee. This is one such agreement. The other 3 agreements are available in volume 9 from pages 1228 to 1257. Volume 9.
Yes.
The another agreement is at 1238 Melo.
1238. 1228 and 1238.
And the third one is at 1248. I hope the same clauses are there. 5 is for the area and 10 is for the compensation.
Yes.
Here the compensation is 50 rupees below. And again at 11 the security. The security deposit is always for 6 months below. And the same thing is at page 1238 also below. Paragraph 5, clause 5 is the area. Clause 10 is the compensation, that is license fee. And then on the next page, clause D is for compensation, the escalation of license fee. And the clause 11 is for the security.
Similar.
Same. And the same is at 1248. Now, based on these 4 agreements, I have made a calculation sheet.
You have placed the calculation sheet before the arbitrator.
Yes, sir. This sheet was not placed before. The other sheet was placed before the arbitrator. I will come to that, my lord. Now here in Milan, your lordship would find that 4 parties are there. I have stated the page number also, my lord.
Yes.
I have stated the area also. I have stated the license fee also. And I have stated the security deposit also. Now, since all the copies of the agreements are not available with me, nor they have disclosed, so what I have done, I have taken an average of these 4, which comes to rupees security deposit for 6 months in all the agreements. Then average license fee, my lord, I have added 4 and divided by 4. It comes to rupees 40.25.
40.25.
Yeah, on day 1. And then the average loading is 54%, my lord. The area for Mohan impression, it is 160 and 240. For exclusive, it is 1169 and 1754. And in Sharma Electronics, 810 and 1168. And in GJF Freedom, 465 and 850. I have added all the 4 divided by 4. So I have come to an average one. So the average loading is 54%, my lord. In the first agreement which I showed, my lord, it was 82%. In the subsequent agreement, it is slightly less. So I have come to an average. Average is 54%. So the total sub-license area is, I have agreed that they can issue sub-license is 31,175. How I have arrived at? Volume 1, disclosure of document. Page 62 probably. No. I will place before your lordship the area of 1,03,918 which have been arrived by them. So I have agreed for 30% of sub-license of this.
Yes.
30% of this. 30% of this area at place 108 million. 108. But after this tabulation, it is stated the above measurement does not match with Mahavir Construction's measurement. After taking into consideration the measurement of both the parties, the final carpet area was arrived at 1,03,918 square feet. So this 1,03,918 square feet is the carpet area. I have agreed for 30% of this that you can sub-license. If they can sub-license 30% of this, it comes to me, Lord, 31,175 square feet.
Yes.
Now, if 31,175 square feet of the area which they can sub-license, and if they are charging 54% of
loading,
more than that, it comes to 48,010 square feet. It's here, no?
Yes.
So, I am entitled for an additional license fee on 48,010 square feet. Next, I have calculated the security deposit. For this area, the security deposit will come to 1,15,094,450. That is 48,010 square feet into 40.25 is the average license fee. It comes to 1 crore 15 lakh.
Yes.
And on this 1 crore 15 lakh, I am entitled for interest of 1.63 crore. The total comes to 2.79 crores. Am I clear, Milord? Claimant on account of security deposits is entitled to rupees 1.15 crore.
And 18% per annum. Okay.
Yes, yes. It is there in my agreement. 18%
Yes.
interest is
Yes.
there.
And
Then additional license fee. For the first 3 years, it will be 40.25 million. For the next 3 years, it will be 46.29 million. For another next 3 years, it will be 53.23. So I have calculated, it comes to 11 crore 91,728. And interest thereon comes to 7.09 crores. And the total is 18.1 crore. So this 18.1 and the security and interest thereon at 2.6, it comes to 20.9 crores.
so there is no evidence to the effect that entire 30% area has been used by the sub licensees.
Even if it is not there, even if it is not there.
It was not before the arbitrator also. That's why arbitrator pointed out that it want more deliberation who is there or not.
I have told them, produce the list of parties whom you have executed. They have not done so. The entire area was covered, my lord. Entire area was sub-licensed.
So that evidence was not placed before the arbitrator.
My lord, in case if they don't give me, I cannot create that evidence at my own, my lord. It is they who have to come forward. At every stage, they have committed fraud. I will establish that, my lord. At every stage.
Okay.
They were supposed to give me this. Had they given me, in fact, they have also executed an agreement with respondent number 4 for an area of around 55-60,000 square feet, where they have taken a security deposit of around 50-60 lakh.
Respondent number 4.
Respondent number 4. That also they have not disclosed before the arbitral tribunal. Now that they have disclosed before the Supreme Court, Honorable Supreme Court, my lord, when they have filed an SLP.
Okay.
Had they given me all this, they would have been made liable to pay me on day 1, my lord, which they did not.
It would be appear after vacation. Otherwise, tomorrow I have some fixed matter. 2 matters are fixed. It will be taken
It is
entire.
also fixed for tomorrow also, my lord.
No. Tomorrow I have fixed other 2 matters. And after this week, I will be there at circuit bench at Jalpaiguri for last 2 weeks.
My only humble submission, my lord, I won't take much of a time. At least this 698, if your lordship could allow me to finish that. Otherwise, after vacation, it will be again a difficult, lot of 4 weeks, 5 weeks, 6 weeks.
Before vacation, I don't have any time. Only I have the time of 7 and 8 October. The group 8 matters are mounting there.
No, I absolutely, as per your convenience, my lord, my only humble submission was that Various documents are there, my lord.
Can you come on 7th at 7th?
I can come on any day, my lord, whenever you.
7th of November.
Whenever your lordship wants, I can come.
7th of November, second half, entire second half. You perhaps concluded the entire matter.
I will do that, my lord.
Yes.
Most of the things I have been able to conclude, and now the rest of the things won't take much of a time, my lord.
Okay. Come on 7th of November.
Grateful, my lord. 7th at 2 p.m., my lord.
2 p.m.
Item number 1 on the top. 7th of October, my lord.
No, November.
That is after puja.
After puja.
After Diwali.
7th of October and 8th of October is the Monday and Tuesday.
My lord.
Generally, Monday, Tuesday, and Wednesday, I take up the group 8 matters.
My lord.
There are several matters pending due to my absence. I would not be possible to take the all matters on 7th and 8th, but
Any day during this month, my lord.
I would not be here. I would not be. I would be the circuit bench for 2 weeks.
Oh, I see.
I would not sit here.
Oh, I was not aware of that. my lord.
Okay, that is the reason I am not placing your matter. Otherwise, I would conclude the matter. Suddenly, it has been come to my notice that I have to go to the circuit of Jalpaiguri to take the bench. Okay. Argument on
7th
behalf
of
of
November, my lord.
7th of November at 2 p.m. Argument on behalf of Mr. Surana, heard in court. Let the matter appear in the list on 7th of November 2024 at 2 p.m.
Grateful, my lord.
Okay.